under Section 36 of the Electricity Act by Scottish Power Renewables Limited to construct a wind farm at Clauchrie, near Bar in South Ayrshire. Before I go any further, can I check? Can you hear me okay? Just somebody,
yes.
Yeah, a few nods, that's good. Obviously we're in the brave new world of virtual meetings, and I hope the technology serves us well this morning. It'd be a great help if people could mute themselves if they're not speaking. And similarly, if there are people who are attending the meeting but don't intend to actually participate in it, if you could turn your videos off. We're here today to procedural arrangements for the inquiry. I realise that some of you won't be familiar with the process for public inquiries, so rest assured that I will be preparing a full note of this meeting, so there's no need for you to scribble detailed notes as you're going along. And that note will set out all the procedures that we'll be following for the inquiry itself, insofar as we're able to agree them today. And if anything arises that you're not clear about as we're going along, then please let me know and I'll try and explain. Now, because there's quite a lot of people in this meeting, though I've got you on gallery view and I only see about a third of you at the moment, so I'll need to keep reminding myself to scroll through to check because you're on 3 screens, but I'll try and remember to do that before we move off any item onto the next item. I need to say that this meeting is being webcast and it will remain available to view on the DPEA website. So I need to make an announcement about that. By contributing to this meeting, you are consenting to the use and storage of video recordings and any information pertaining to you contained in them for webcasting and training purposes and for the purpose of keeping historical records and making those records available to the public. Now, an agenda was circulated in advance of the meeting, which I hope everyone has received. Has anybody not received it?
Hello.
Hello.
Hello. This is Sandy Miller from Clauchrie, Straighton.
Hello. Have you just joined the meeting? Hello. Okay, you're breaking up a bit, Mr. Miller. I think you've just joined the meeting, have you?
We just joined and we've done a video and noise test. That's okay. So we can see ourselves now. To a few others.
Right. I'm afraid.
Did you catch all of that?
I'm afraid you are breaking up a little bit. So I don't know if that's something Graham.
We're yourselves.
Right. Can you hear me?
Yeah.
Or...
We can hear most of what you say. You're getting small breakups.
You're now
we are
frozen
on
video,
only something like 5 megabytes. What that was.
Right. Well,
other computers, and we're on about 5. That's about it. So.
Right. Well, if you could try and if you have got another means of accessing the meeting on a different machine or in a different room with better access, then if you could perhaps try and do that. I don't know how much we can do at this end.
I'll get Christine to come and sit at this one, and I think she's actually shutting down most of what's on the other machine at the moment, because that's the one that's on hard wires to the router. We're on just on. We don't have it in another room, so that might be part of our problem. I've managed Zoom meetings with 13 before now, quite happily on this.
Okay, well, you are coming through a bit better now, so maybe that's helped a little bit.
Yes. Yes.
All I can.
Single wire, the crocodile clips are working well.
Okay, good. I mean, all I can say is that there's a risk that some people might drop off from time to time. But as I say, I will be prepared to the meeting. So if you do miss any parts, then everything will be set out in the note. And if there are after the meeting or parts of the meeting people missed and they wish they'd made a contribution to, then by all means people can put that in correspondence by email after the meeting, and we can deal with that as correspondence. Okay, so if I can move on then, and if I could ask the parties to, starting with the principal parties at any rate, to introduce themselves and any colleagues they have with them today, perhaps starting with the applicant, and I think that's Mr. Innes.
Good morning, sir. My name's Colin Innes, and I'm a partner in the law firm of Shepherd and Wedderburn, and I appear on behalf of the applicant. I'm instructed by Fiona Coyle of SPR Legal, and I'm also joined by members of the project team as well today, who are not on camera but are here and listening. Thank you.
Thank you, Mr. Innes. And for South Ayrshire Council, Mr. Campbell, are you here?
Sir, good morning to you. My name is John Campbell. I'm a Queen's Counsel at the Scottish Bar, and in this inquiry I'm representing South Ayrshire Council, instructed by Christine McMenamin of the Council's Legal Department. I have members of the Council team with me, although I don't see any of them at the moment, but I'm sure they're listening. The Planning Officer and the Environmental Health Officer, the Planning Officers.
Right, thank you, Mr. Campbell. I'm just having a message saying that part of the problem with the connectivity might be at my end, but we'll press on. For Nature Scott, can I hear who's present, please, for Nature Scott?
I can hear it.
Good morning, this is Jennifer Jack. I'm a partner in the law firm Harper McLeod, and I'm representing Nature Scott. I'm joined at this meeting by Lindsay Kinnis of Nature Scott, although I understand she is having difficulty hearing anything at the moment, so I'm not sure whether she can actually follow proceedings at the moment.
Right, okay, hopefully, as I say, I hope that's not all at my end, but is it me that's breaking up, or is it?
I'm certainly able to hear you and haven't had any difficulty in hearing anything so far.
Okay, well,
Although having said that, I think you just disappeared at the moment from my screen, so.
Right, okay. Can people hear? Can people hear?
I'm getting quite a lot of feedback from someone possibly not being on mute at the moment.
Okay, can people hear me now? Yeah. I think maybe if we are having difficulties here, if people could switch their videos off until they wish to speak, that might help. You can't hear me, to try logging off and logging on again. Right. Good. Ms. Jack, can you if you can hear me?
I can hear you most of the time, sir, although again, you have just frozen on my screen at the moment and now you've disappeared. So there do seem to be a few technical glitches going on at the moment.
I don't know, Graham, as our IT expert, have you got any suggestions here?
Yeah, come in, just coming in there. Steve, your bandwidth is dropping up and down all the time. That's why you're having the problems. Others can't hear, so I've asked them if they can log out and log back in to see if that will stop their issues. We can't really help the issues that others are having, except with logging out and logging back on. But your bandwidth is fluctuating quite a bit, and you're pausing and your video stops quite a bit.
Okay, well, shall we, I suggest that we adjourn for 5 minutes, and maybe I'll try and relocate my position in my house, and right, hello again, everybody. I've relocated myself into a different room in my house, which is going to be slightly less satisfactory for me because I'm not next to my computer screens, but hopefully I'll be able to cope with that. Can people hear me now?
Yes.
That seems much better.
Right. Good. I think the issue is when we do testing, we're just testing with one stream on, but then as soon as we get so many different streams, the requirements on bandwidth, I guess, are so much greater. So apologies if that was a fault at my end. So if people are now with us again, I was just going through the introductions at the start, and I think we'd heard from the applicant and the council and from Nature Scott. Do we have anyone here from Glasgow Prestwick Airport?
Yes, we do. Sir, my name's Douglas Blythe. I'm a partner with Denton's Solicitors. I'm joined by Steve Thompson, who is a manager of air traffic services at Glasgow Prestwick Airport.
Thank you very much. And from Bardachat and Knockdolian Estates, do we have Mr. Kelly?
Thank you, sir. Good morning. Yes, I represent the two estates. I'm Ian Kelly, of Chartered Town Planner. Can I also say, sir, that I've been contacted by Mountaineering Scotland, who are objectors to the scheme and who should have been taking part in this pre-inquiry meeting. They do wish to take part in the inquiry. There seems to have been some lost communications, but I undertook just to mention the fact that they will be participants in the inquiry.
And will you be representing them as well?
No, sir, they'll represent themselves. For the moment, I just undertook to raise the matter on their behalf.
Okay, well, it's unfortunate if there's been...
You've frozen again, sir.
People hear me? Yeah, somebody can hear me. That issue of Mountaineering Scotland, but that's unfortunate if there's been a breakdown. And for the Southern Ayrshire Biosphere, do we have Mr. Thompson?
Yes, I'm a trustee of the Galloway and Southern Ayrshire Biosphere who have objected to this proposal. I'm intending to attend part of the inquiry, but certainly not the whole, which I think takes us on to some of the questions you're going to be raising later on.
That's thank you, Mr. Do we have on behalf of
I think you were referring to me. You were breaking up. This is Mr. Heggs. Yeah, my name is John Nolan. I'm here as a spokesperson for Save Straight for Scotland, which is a campaign group, a community campaign group, which is objecting to this. So I'm here to talk on behalf of a number of people listed in Section 2, which we'll get to as well. So that's me. Okay, good morning, sir.
Thank you, Mr. Nolan. Susan Crosthwaite. Or is Susan Crosthwaite here, or Mr. Grosvenor? Are you?
Yes, Susan Crosthwaite, I'm here, but I can't hear you all the time. You're fading in and out. This isn't very satisfactory because I can't hear what you're saying all the time.
It isn't. I mean, I don't know how much. I can't take any more action at my end, I don't think, beyond what I've done. If it's an issue with my bandwidth, that's very unfortunate. I mean, if we have real difficulties, then we'll just have to reschedule for some time in the new year, which would be, as I say, unfortunate. Graham, I don't know if you're still there. Am I coming across in a satisfactory way, or how is this going?
It's a little bit better, yeah. I'd say it's a little bit better. You're not breaking up as much. I don't know if you want to even switch your video off to see if that helps.
Okay.
Just so people can hear you. That might be an option for yourself if parties are okay with that.
Well, we'll try that. I mean, that you'd think that my video would have a particular impact on the bandwidth, wouldn't you? Because that's being broadcast out. So we'll try with that. Miss Crosthwaite, if you can hear me.
Yes, I can.
Yes. Hopefully that's a bit better. And,
okay.
And you've got Mr. Grosvenor with you. Is that right? Or not with you?
Yeah. Mr. Grosvenor he's I can see him on the call. He's not actually with me, but we are. It's a terrible line. It's echoing back to me all the time as well. But Mr. Grover and I and Dr. John Yelland will be representing Chris Shaw and others on the noise situation.
Okay, thank you. And then Harriet Ellis. Is Miss Ellis here? Okay, perhaps not. Mr. and Mrs. Miller.
If I can intervene, that Miss Ellis was here earlier and appears to have disappeared offline, and I'd be concerned that it appears that there appears to be perhaps another technical issue, sir, on that one.
I am here. Sorry, I'm here.
Okay, good.
Yeah.
Right. So that's Harriet Ellis. Mr. and Mrs. Miller.
Yes, we're here. We've only been able to make one call through. We are.
Yes, I'm afraid you're breaking up very badly, Mr. Miller. There, sounds like you've got similar problems to me with so many people being on this call.
We have only five. We only 5 megabytes all told.
Yes, it is certainly a challenge, but we'll have to press on, I think.
But if I stop stopping our video may help. I'll just give it a go. Right. Can you still hear us?
Yes, that's sounding a bit better. Yes.
Right. I'll leave video off then.
Yes, I think that probably helps, and hopefully I'm coming through a bit clearer now as well.
Yes.
Ms. Rofe. Amanda Rofe. Not here today. Mr. and Mrs. Shaw.
We are here, sir, yes. Struggling a little bit with the audio, but we are here.
Okay, well, you're coming through loud and clear, so that's great. Ms. Spence, I think I can see you there.
Yes, I'm here.
Good, and I can hear you, that's good. And finally, in terms of people I was expecting to be here, Nikki Spinks, and I can see you as well. Can you hear me?
Yes, I can hear.
I can hear you, that's great. Now, are there any other parties here today who are expecting to participate in the inquiry?
Yes, Joy Kendall.
Joy Kendall?
Yeah.
And did you receive the opt-in letter from us? And
I have done, but it's been sent at a later date. I wasn't included on the initial send.
Oh, right, I see. Maybe that's why you're missing from my list. And are you a local resident?
I am, yeah.
Okay, I'll add you to the list. That's fine.
Thank you.
Right, that's got us through item 1 in the agenda. Does anybody have any preliminary points they want to make at this stage before we go into the other items on the agenda? No, good. Then let's move on to item 2, which is the application of the Code of Practice and the types of procedure. So there are no statutory rules relating to Electricity Act cases. So the inquiry will be dealt with in accordance with the Code of Practice for these cases. And this is available from the DPEA website. And I'll include a link in the notes of the meeting. Essentially, the approach in the Code of Practice allows for flexible procedures. We'll look to deal with each issue by the most appropriate mode of examination. This could be an inquiry session, a hearing session, or further written submissions. On some issues, we may decide that I already have sufficient information from the information before me, and that no further procedures will therefore be required. Now, I don't make the decision in this case. Scottish ministers make the decision and I write a report for them. And in writing that report, I'll take into account all the environmental information submitted by the applicant, together with all the consultation responses and letters of representation that have already been lodged. So the type of procedure being followed at the inquiry itself, or the absence of any further procedure, is not an indication of the importance of a particular issue. A list of topics and my provisional assessment of how each topic should be heard was circulated, I think, as Appendix 1 to the agenda. But before we look at that, I just want to explain briefly, particularly for people who haven't been involved in this type of process before, what the difference is between a hearing and an inquiry session. So hearing sessions take the form of a structured discussion, essentially a round table meeting between the parties involved, which I will chair and I will lead. There won't be any formal leading of evidence or cross-examination in a hearing. I will prepare an agenda for each hearing session based on hearing statements, which all the participants will prepare and submit in advance. So I'll use those hearing statements and other evidence to prepare an agenda. Everyone who's advised us that they want to take part can participate in a particular hearing session. You can make your own case, but there's also the option to what others have said. There's no need to be legally represented at a hearing, although parties' lawyers can take part in the discussion if they wish. So hearings are generally more informal than inquiry sessions, and they're particularly well suited for topics where there's a difference of opinion on less technical issues. Inquiry sessions are different. In these, the witnesses for each party will be invited to prepare precognitions in advance, which are essentially transcripts of the evidence that they intend to present. On the day, witnesses are usually asked to read their precognitions in whole or in part. Evidence is presented in turn, and this will be subject to cross-examination by those of the opposing view. Usually, parties in inquiry sessions are legally or professionally represented, and lawyers will cross-examine the witnesses. But I must say, it's not essential to have a lawyer. One can appear on one's own behalf at an inquiry session. And I may also have questions to ask. And then finally, the witness may be re-examined by their own lawyer or representative. So inquiry sessions are more formal than hearing sessions, and they're particularly well suited to topics where there's a lot of technical evidence. And finally, some topics may also be addressed through written submissions. These may come about through responses to specific questions from me. And they might range from broad invitations to submit more views on a particular topic to maybe quite specific queries on particular detailed points. Does anybody have any questions at this stage about the procedures and process? Okay, then if people are happy, we'll move on to item 3. And if people could refer to Appendix 1 of the agenda. So my provisional assessment of the main issues to be addressed in my report and those requiring further procedure is summarised in this table. So one of the at the bottom there, you'll see. I mean, a traditional inquiry would go through the topics on a topic by topic basis. But we found in some inquiries, particularly where there's quite a lot of parties involved, that it's been more easy for people, easy for the reporter as well, I must say, and more efficient in use of time for people to be heard on a objector by objector basis. So I'd like to have a short discussion about whether we think that could be a possibility in this case. I'm conscious that where concerns centre around, if you like, the across-the-board impact that the wind farm could have on people's quality of life, that's quite a cross-cutting issue that could be dealt with in a piecemeal way in terms of residential amenity, visual impact, noise, and so on. But it might be easier for people to present their case just in a single session. It would also mean that objectors would only have to attend and give evidence at the inquiry once, and would only have to prepare a single submission. But I'd stress that we could only follow this approach for non-technical evidence and non-professional objectors. And a disadvantage might be that I wouldn't envisage there being an opportunity to necessarily ask questions of the applicant's witnesses in this format. But it might be possible for individuals to mix and match, for instance, by attending the landscape and visual impact session and then presenting their other concerns in a single separate sitting. So I'd like to get people's views about that. Perhaps I'd ask the applicant first, Mr. Innes, if they would have any difficulty with this approach, and I suppose your experience of following this kind of approach in other inquirers.
Yes, thank you, sir. In essence, I think the approach is one where essentially you're seeking to afford parties who may not want to participate in formal processes an opportunity to be heard in an instance where they can deal with all the matters and raise them with you in one go, whilst there will, of course, also be formal sessions relating to some of the matters that may be raised by those individuals. It really, in my view, as the applicant, we're happy to participate in any proceedings, and equally we're quite happy to participate in proceedings whereby parties who may wish not to participate in formal proceedings but want to participate in the process as a whole are given an opportunity to be heard and to make their points often at a time which might be more suitable to them as opposed to necessary during the formal sessions. So we would have no difficulty at all with that flexibility if that's something which is desired by any parties to the process.
Thank you, Mr. Innes. That's helpful. I mean, I don't know. I'm not necessarily expecting people to commit themselves to this, to such an approach today. But I don't. Has anyone got any questions about this approach? Mr. Campbell, you've got your hand up. Let's start with you.
Thank you, sir. I don't have a question, but could I join with Mr. Innes in saying that the council is quite happy to adopt either of the approaches which you have briefly outlined in this appendix. Experience suggests, sir, that it is often beneficial for the inquiry process if those of like mind can combine their representation so that we're not hearing the same thing over and over again. That's not to diminish the quantity or quality of the objections, but simply for efficiency's sake. But it's not up to me to suggest who should combine with whom, simply to float the idea so that people may want to consider that.
Yes, thank you, Mr. Campbell. We'll certainly be coming on to the possibility of people combining to give joint evidence as well later in the meeting. Ms. Spence, yes.
I'm rather concerned that you may not consider the as seriously as you consider that you receive an inquiry, particularly people like me who don't have the sort of qualifications that all these experts that the applicant is putting forward. I mean, my experience of it is that every time I say something, they say, oh, you're not an expert, so you can't prove it. Well, I experience things that I can't prove because I'm not a technical person. In other ways, I'm a technical person because I'm a professional musician. So within, for instance, with a noise problem, which is major for me, this is a great difficulty. But as a musician, I have qualifications of what I can hear and what I can sense and how difficult it is to operate as a musician without having the necessary technical knowledge to put this in an acceptable format.
Yes, thank you. I'm not sure if you've dropped out, if you've stopped speaking.
Sorry, yeah, I just stopped speaking because I more or less said what I.
Yes, no, that's helpful. Thank you. I mean, certainly, the use of a hearing session does not in any way diminish the importance that is given to an issue. Many planning appeals and inquiries are dealt with by hearing sessions, including very often only hearing sessions and not having any inquiry sessions at all. A big advantage of hearing sessions is thought to be by most participants that they're easier for non-professional, non-planning professional people to participate in because it's a more natural conversational style of session. So I wouldn't in any way want to put you off having or preferring a hearing session for that reason. And I suppose it's probably also the case that hearing sessions I am more actively involved in because I am chairing it and I am setting the agenda and leading the discussion. So I don't know if that helps put your mind at rest at all. Any other questions at this stage? I'm not seeing anyone else waving. I mean, as I say, I think this is a matter that we can come back to perhaps under the next item where we're talking about who wants to be involved in which session. People could maybe give an indication there about whether they'd prefer to come to, if they have a range of different concerns, whether they prefer to be involved in all the individual sessions or just come along and give a single piece of evidence to me. So if we come back to Appendix 1, and you'll see that I've grouped the issues in Appendix 1 largely following the scheme set out in the EIA report. Are people happy with the way that I've grouped issues there? Have I missed anything out? Do some of these issues need splitting up? Perhaps if I could, again, Mr. Campbell, you've got your hand up first, so we'll start with you.
Thank you. Just in relation to the landscape and visual bracket, if you like, you've included wildland there. Nature Scott and I have had the benefit of a conversation, as have our, and also with our expert, and we think that wildland should be a discrete session within that bracket. I think Mr. Innes is in agreement with this, but he's nodding wisely, so I think that's a sure sign. But I don't see it as being necessary to have a separate subject heading. It's just that the wildland issues are separate and distinct from the other landscape issues. And we think it would be easier for you if it was treated separately.
So potentially there could still be a landscape and visual session, but we'd hear wildland witnesses maybe first, then move on to having other landscape witnesses after that.
That's correct, yeah.
Okay, well, I don't think I'd have any problem with that. Mr. Innes, does that sound suitable?
As I say, we have been contacted and we've had the discussion and understand that really represents Nature Scott's key issue in the context of the inquiry. It is readily suitable to be treated as a separate issue. It is, of course, linked, but has its own particular aspects and its own particular assessment, etc. So in some ways, I think in terms of whatever procedure we may be adopting going forward, anything that is slightly more focused is probably easier in the context of these proceedings than the wider. So I think anything that narrows things down and makes it more focused probably assists in the subsequent handling, depending on how and when it's dealt with.
Okay.
I do have other comments on other topics, if that's helpful.
Sorry, this is my phone going off here. I'm in a different room. Apologies for that. Well, while we're on this subject, should we just, if I could just ask Ms. Jack from Nature Scott to just confirm she's happy with that arrangement to separate, semi-separate out wildland.
Yes, Nature Scott would be very happy with that. They have a particular interest in the issues connected with wildland, and they think that it would be sensible to treat them discreetly from the broader issues that we're relating to landscape and visual issues. So they're very happy with that proposal.
Okay, well that sounds perfectly sensible to me. So I think we can proceed on that basis. Mr. Innes, you had other comments to make.
Yeah, I probably should make them all, and hopefully they're not too voluminous, and that will just set out the applicant's position in relation to matters. In relation to planning policy, energy policy, and the electricity benefits, our view is that this is actually growing in complexity in terms of the policy framework, and it would benefit from at least a hearing session in order that we can have a proper debate, because I think there are differences of opinion as interpretation of policy. The other matter is that it is continuing to emerge, and therefore we're having to deal with developing policy as well. And I think the thought process is that experience has shown that this is an area which does benefit potentially from some element of discussion, and we would say a hearing at least. In terms of topic number 2, the radar mitigation issue, I'll call that the potential impact on Glasgow Prestwick Airport, is one issue. It is not related to lighting, that's a separate issue. And obviously there's a separate topic matter in the agenda that we'll come to about that particular aspect. But if needed, it's probably more a component of the landscape and visual, and it's certainly relevant in the context of wildland, for example. So I don't think it sits easily in the aviation topic in some respects, and it would be a distinct topic. But as I say, I will address you later on that point because it's a topic you want to come to, and I'm hopeful that we'll make progress on that particular issue, and that will essentially hopefully be progressed, and it wouldn't need a separate topic area. And insofar as the procedures for landscape, visual and wildland, the applicant believes these are key issues, and they are ones which they think should be properly ventilated through an inquiry session. It is likely that the parties will need expert evidence, and it is right and proper that that expert evidence should be properly tested. There are already apparent from the papers that have been submitted different professional views, and we consider, given the importance of these matters to this particular inquiry, that should be properly canvassed in the context of an inquiry session. Apart from that, so we're relatively content with what's proposed, and would be happy to participate in the various proceedings that have been set out. I don't think I really have anything further to add on that Appendix 1 timetable at this stage. Thank you.
Thank you, Mr. Innes. I mean, on the planning policy issue, I'm not wedded to it being necessarily by further written submissions. So if there's an appetite for an oral session, then I would be willing to entertain that. I suppose I just feel these matters are quite well rehearsed, but as you say, the landscape in this area is changing all the time. On aviation, I do take the point about radar mitigation and lighting being separate. What I was really hoping to do, though, was to deal with deal with the lighting issue before we go on to the landscape issue, so that we know when we're looking at the landscape and visual impact discussion, particularly about the lights and the night sky and so on, we know exactly what it is that we're dealing with in a technical way. Mr. Campbell, do you have anything further to add, having heard what Mr. Innes has said?
I'm in agreement with him on the question of policy. At least a hearing on that question. It's a dynamic picture, and it does need some discussion. I don't have anything to say about topic 2. As far as landscape and visual matters are concerned, I agree with Mr. Innes. Don't want to add anything. There will be experts on both sides. They should be examined properly. As far as hydrology is concerned,
you'd also prefer an inquiry session on landscape.
Sorry, I thought that was implicit. Yes, I would also prefer an inquiry session on that topic.
Thank you.
And I should mention that Nature Scot and the council share an expert, so we're only talking about one witness there, apart from the planning officer, who will come in earlier on, I think. So far as hydrology and hydrogeology are concerned, I'm in agreement with your assessment, and the same is true of peat. And those, I think, aside from conditions, are the only matters on which the council wishes to be heard. Experience suggests that conditions are best dealt with at a hearing and not at an inquiry session. And I'm able to report to you that there has been good progress in working on the conditions, although we're not quite there yet.
Okay, that's encouraging. We'll maybe come back to conditions later on. I mean, we've slightly jumped onto the merged this discussion with a discussion of what form of session we'll have for each of these topics. If I could bring us back just to the way the topics have been grouped at this stage. Does anybody else have any comments just on the grouping of the topics at this stage? Right, I'm not seeing anybody waving there.
Sorry, on behalf of Glasgow Prestwick Airport, if I could just comment on the aviation aspects, which is grouping 2. As I understood it, I think Mr. Innes was suggesting that the technical aspects of lighting, there would be some benefit to separating them out. I think largely on the basis that he anticipated the lighting part is capable of being progressed and potentially dealt with. And I think on that basis, it does seem to me to be some sense in separating out technical aspects of lighting from the question of radar mitigation, because the 2 issues are quite separate and distinct. And and naturally, if one can be addressed and dealt with, it'll help to limit the scope of the inquiry session, which would seem to be appropriate for radar mitigation.
Yes, can I just confirm if the airport has an interest in the lighting issue as well, or is it just the radar mitigation interest that you have?
The airport's principal objection relates to the radar mitigation issue, but as I understand it, certainly there is a lighting requirement in terms of the CAA, but I'm not anticipating there really being any particular difficulty in that being addressed. I think the requirement is understood by the applicant, and as I understand it, and certainly from what Mr. Innes was saying, is steps are being taken to address the lighting requirements. So Glasgow Prestwick's principal objection relates to the mitigation in respect of the radar as opposed to lighting.
While we're on the subject of the radar, then the airport has submitted its updated position paper in the last few weeks. Is there any further update to give about further discussions that are taking place or prospects?
Yes, it might be helpful, sir, if I just update you on where matters are in that respect. Without wanting to get into the detail of the objection, the principal issue is one of radar clutter caused by the wind farm. That clutter, the airport anticipates, is capable of being mitigated by way of a technical solution. And the document which I've prepared provides a bit more detail in relation to the background to the issue and the background to the potential solution. Now that document's been provided to SPR on the 25th of November with a suggestion of a discussion around the terms of a possible wind farm mitigation services agreement. The reason for the need for that agreement is that whilst there is a technical a solution to the radar clutter, it requires the use of further technology, and it requires calibration of that technology and testing of that technology, etc. And that all needs to be done appropriately in order to ensure aviation safety, which obviously is the primary consideration. And where matters are at currently is that that document, which provides the further details, being provided to SPR. In addition, a draft non-disclosure agreement has been provided to the applicant, the non-disclosure agreement being required in order that the airport can provide the draft mitigation services agreement. And as matters stand, we're simply waiting to hear from the applicant in relation to the non-disclosure agreement, which will then allow us to provide the draft mitigation agreement, which will then allow us to discuss the commercial terms. And if all of that can be agreed, then I would anticipate there's a good prospect of the objection being withdrawn. But I would be keen to see some progress being made in relation to a dialogue with the applicant in that respect, because what I don't want to happen is for us to end up with an inquiry and all the attendant preparation being undertaken only for matters to be resolved on the evening of the inquiry.
Yes, I certainly share that sentiment. Do you have any sense for timescale about how long these things typically take to get to from position to the position where you could withdraw your objection?
Well, I think to an extent it may be a matter for Mr. Innes. I think the first thing we require is simply a response to the non-disclosure agreement. It ought to be fairly unobjectionable, to be frank, and once that's been entered into, the draft services agreement can be provided. It can be discussed, and I would envisage ought to be capable of being agreed. Assuming an agreement can be reached on the commercial terms, it ought to be capable of being agreed in fairly short order. But we just need to progress the dialogue in that respect.
Okay. Could I come back to Mr. Innes then on this point of radar mitigation and progress?
Yes, thank you, sir. In terms of the position, my clients have obviously engaged services of technical specialists. They've received a report, and we are in some degree a degree of difference with the airport over the conclusions. Those need to be resolved, and I don't think it is quite as simple as has been expressed in terms of where we are in terms of progress. It remains fundamental differences that need to be resolved, and at this stage, I can't give any guarantees as to the timescale of how quickly that will occur or not occur. What I can say is that we are evaluating the airport's position, which we will do so properly, but we need to be satisfied, and that's what we are currently evaluating. Depending on the outcome of that, we will go back to the airport and have further discussions. But there are difficulties in terms of some of the complexities regarding the proposal about non-disclosure, but these are not really matters which I'm currently instructed on and have detail of. So I would probably have to say that I would say we're at an earlier stage of the process than we might want to wish. And that is why, if we are going to fix a timetable for this issue, it should be at the tail end of the whole process. And I think, to be clear, that if there needs to be an aviation session, it would be more than just radar mitigation that we'd be talking about, because what we'd be talking about is the impact of this proposal on the radar. We'd then also be having potential evidence about its impact on air traffic control, management of airport, and also potentially what's proposed. So I just pose that if this matter can't be resolved, that the aviation session needs to be fixed with sufficient time, because it's not as simple as straightforward as suggesting that it would be a straightforward issue of mitigation. These matters tend to be to have a broader context, and it's not, as I say, it's something which would take some time, and it's not, as I say, just one little small technical issue that might be the impression given. It would require a significant number of witnesses, and it would be covering more than, I say, just the radar assessment. It's the implications of those assessments, and also the implications of the location of the particular proposal relative to airspace, etc. So all those matters would have to be canvassed. So what I would say is, yes, we need to keep progress in mind, but equally at this stage of a progress, I'm not suggesting that we're at a stage where we don't need to timetable towards the end of the inquiry some time period to potentially resolve this particular issue.
Thank you, Mr. Innes. Yes, we'll certainly need to schedule it in at this stage. Ms. Spence, you've got your hand up.
Yes. Does this not just show the premature application for this project to have 200-metre high turbines when no system was even hardly in concept, let alone being proved to be possible, and that they're probably wasting our time still faffing about trying to invent something that might work at this stage?
Well, yes, I don't want to get into the. I mean, that's straying perhaps into the evidence of the merits of the case. But certainly you've made your point there. If I could return us. Oh, well, actually, while we're on aviation, perhaps we should. That was a useful discussion about the radar issues. Perhaps again, Mr. Innes, is there anything you can update us with about the lighting issue?
Yes, we're at a more advanced stage in relation to the lighting issue, and would hope by the beginning early next year to be in a position to formally update the inquiry as to the applicant's position regarding aviation lighting. We have made substantial progress, but as I say, we're just finishing a final part of an exercise that is due to complete in the next couple of weeks, and we would hope to be able to advise the inquiry early next year. I think it is important that this matter is crystallised early because it is an important topic relative to landscape and visual and also wild land. And therefore, in terms of preparation time and consideration, I'm fully aware that we'd need to take a decision and notify parties of this early next year to ensure that it doesn't cause any delay to parties knowing whether or not they have to deal with that particular matter. So, as I say, I think we'll be able to do that early in the new year, and perhaps arising out of today's meeting, we could set a time limit for the applicant to come back formally on that particular matter, and then everyone knows the deadline that we're working to in order to confirm that position.
Did you have a particular time limit in mind?
I was hoping that we could assume that we were back at work and at least had a week. So I was thinking something around that first week, the sort of second week back in January would probably be a time period in which we could meet.
And this progress that's made, presumably the applicant is in discussion with other parties but not with the actual objectives at this stage, not with Nature Scott or Council or.
This is more a technical evaluation of the potential for alternative solutions, which we, depending on outcome, would commit to as part of the project, i.e. that the project could not potentially operate without those being in place. And that's what is the outcome of that particular process.
Okay, thank you. Perhaps I could turn to Ms. Jack then at this stage. Is this music to your ears at Nature Scott?
So you were breaking up slightly there, sir, but I think you're looking for my input.
Yes, please.
Session 2. I think you'll have gathered from the discussion thus far that I think the parties are anticipating that session 2 would be dealing with technical matters, whereas I think Nature Scott's primary area of concern is in relation to the impact that matters, including aviation lighting, would have, particularly for Nature Scott on land. I think for those reasons it would be Nature Scott's preference not to be involved in session 2 and to leave it to the technical experts who would be able to discuss matters both from the applicant and from the council's perspective, rather than them becoming involved in that session. So as matters stand, the preference of Nature Scott would be to not have involvement in session 2 dealing with aviation. They would of course want to deal with the impact of aviation lighting if it remains a live issue within the landscape and visual session.
Fine. I'm conscious that it would potentially be a one-sided session on lighting in opposition, but Mr. Campbell's got his hand up here, so maybe you can come in here, Mr. Campbell. I think you're muted, Mr. Campbell. You're still on mute.
All I would want to say, sorry about that, all I would want to say is we're not in opposition to Mr. Innes on any question of lighting at present, but we would want to stay informed. So perhaps even passively, we would want to take part in this session, or I and the planning officer would want to take part in this session, really to help you to see if there's any policy issues which you might want to consider when looking at Mr. Innes's proposals when they come forward.
Thank you, Mr. Campbell. Mr. Innes was suggesting that by the second week in January, he may have more information here. So coming back to, we've got a hand up, back to you in a second. But coming back to Ms. Jones, I would make a decision to look at that in mid-January and take a view on this new information?
Well, Nature Scott can certainly look at the new information, that's not a difficulty. I think that the principal difficulty that Nature Scot would have is that if evidence of a very technical nature, as has been discussed this morning, is to be led at an inquiry session, they would not be proposing to put forward a technical expert to counter anything on the technical aspects of lighting that might be said on the part of the applicant. As I say, their principal interest is in relation to the impact that aviation lighting might have in terms of landscape and visual in respect of wild land.
Okay, understood. Blythe.
Yes, thank you, sir. I think from the perspective of the technical aspects of the lighting, I think Glasgow Prestwick Airport would also want to review what is proposed. But as I say, I would be hopeful that the proposal there is capable of addressing the issue there. And I think the suggestion of a timetable from Mr. Innes is very helpful in that respect. I think it would, coming back to the radar mitigation point, I think it would equally be helpful to agree a timetable for the response from the applicant to firstly the proposed non-disclosure agreement, and secondly, assuming we get past that, to the proposed mitigation services agreement. Because what I'm keen to bottom out is whether or not the applicant is agreeable to entering into a mitigation services agreement in principle, because certainly from Glasgow Prestwick's perspective, if that agreement can be entered into, that allows the objection to be withdrawn, assuming it can an agreement is reached on acceptable terms. And that thereby negates the need for there to be any inquiry from Glasgow Prestwick's perspective into to the issues which were referred to by Mr. Innes. I think if the applicant's position is that it is either not interested in entering into a mitigation services agreement or does not consider that it's obliged to enter into a mitigation services agreement, then I think it would be helpful to bottom that out sooner rather than later. And I think if we could frame a timetable to accommodate that, I think that would be useful.
Thank you, Mr. Innes. Would your clients be prepared to commit to a date in January or end of January for responding to the information from the airport?
There is a difference, sir, between the aviation lighting issue and matters relating to Glasgow Prestwick. And it relates to, there's a technical issue and there's a consequence of technical issue where we may or may disagree, and then there's a commercial issue. And just to be clear, that the non-disclosure agreement is very broad, and that's the issue that we may have. We're happy to have potential further discussions, and we can look at it, but I just want to make clear that may be an issue, but that may be a commercial issue, and I don't think it's quite as straightforward in a planning sense that we can at this stage essentially potentially be put in a position whereby we're put in a non-disclosure agreement and then aren't actually able to tell you what's going on in part. So, as I say, I'm happy for the applicant to go away and to go back to Glasgow Prestwick Airport. I think it will take slightly longer than mid-January to be able for us to go back fully on that, and for there to be an update perhaps between the parties around mid-February as to where we've got to, because there may well need to be further discussions, and we need to work out whether indeed there's a potential for us to resolve matters or whether the matter has to be resolved before you. But I think it might take slightly longer, and it's not just about a single response to the letter, that there are wider issues and some of them aren't planning issues. So as I say, I think that's the issue that I would have in saying, you know, should you be involved in setting timetables? Yes, you should, insofar as they relate to matters before you, but where they relate to commercial matters, that's really a matter between the parties. And I think all that you can really be to be in terms of an inquiry session is where have you got to, and are we likely to have evidence on the matter? And I think that will take, I think, longer than the second week of January to work out where that position is. That's just what I'd say. That's my my clients are considering the material, but I don't think it's likely that we'll reach a resolution between the parties by mid-January. I think it will take longer, and I'm just saying that to be realistic.
Mr. Blythe, does that sound reasonable to you? Mid-February for some sort of position statement, ideally a joint position statement setting out any remaining differences between yourselves and the applicant?
I take the point that it's difficult for you, sir, to set a timetable in relation to commercial matters, but the point I make is simply that Glasgow Prestwick's perspective, its objection ought to be capable of being dealt with if we can enter into a discussion relative to the appropriate terms of a mitigation services agreement. But the difficulty I have at the minute is that we can't even enter into that discussion, because for us to provide the draft agreement, we need to agree terms on non-disclosure for the obvious reason of protecting commercially sensitive information. I think perhaps from your perspective, sir, all that can really be done is to set a date by which you would like to hear back from parties relative to progress, and if parties are to undertake to try and advance matters between themselves as much as possible during that period, then I don't think there's more that can be done than that. But what I would say is that I think it would be helpful to have if there are particular issues with the terms of the non-disclosure agreement which is proposed, it would be helpful to have a response on those issues sooner rather than later. And I dare say these things are capable of being negotiated to a degree, but we need to start the dialogue.
Yes, well, I think I just need to leave it to the two parties to have that dialogue, and certainly I'll minute that it would be helpful to get an update from you in mid-February on that. If I could move on to the hydrology and hydrogeology issue, I think the main issue here is private water supplies, and I've suggested a inquiry session in this area. We have had this additional study prepared by the applicants on this topic, which I hope everyone, well, I think some people with an interest in this area have now seen. I think this was submitted to the Energy Consents Unit, but perhaps didn't initially come on to us at DPA. At least I couldn't identify it among the papers, but we now have it, and I know that Mr. Shaw and I think Mr. Campbell now has it, and it's been uploaded onto our website. But I'm not sure that everybody with an interest in private water supplies will necessarily be aware of or have seen this new study. But perhaps Mr. Campbell, in the first instance, I don't know how long you've had to see this document, but whether this was an area where the council had an objection, and whether this new information has assuaged your concerns at all.
In this context, no, it hasn't. We're not in agreement with the conclusions of the report. I have seen it, and I haven't yet got an expert response from those instructing me, but I will be getting one, and we wish to join issue with the applicants on this question.
Thank you. Right, so for the time being, you still wish to be...
And we agree that an inquiry session is an appropriate form of inquiry for this matter.
Mr. Innes, I think you have also stated that an inquiry was appropriate here.
Yes, sir. Hydrology by its nature is specialist, and it's far better that it's got those formal procedures around it. Having dealt with these issues before, it does need to be properly ventilated, and it's a matter of some detail. I've dealt with it at hearings. It doesn't really work. The evidence needs to be properly tested and considered.
Perhaps I know, Mr. Shaw, you have a particular interest in private water supplies, and and you've now seen this document, but presumably, well, I shouldn't presume anything, but are you wishing to maintain your objection on this particular matter?
I am, sir, and I'm wondering whether this is the appropriate application of this this document, or whether you prefer to do that under Section 9.
I think let's deal with it now. Get it? We're at the yes, we're at the issue of private water supplies now. So let's deal with it.
Okay.
So about whether this needs to be formally publicised as an amendment to the EIA report.
That's right. I mean, the covering letter suggested that it was merely a little bit more information to the environmental impact assessment, but when you read it, it seems to include quite a bit of additional information. For example, Mark Farm appears for the first time in this document, and I wondered therefore whether in fact it was of such consequence that it shouldn't have been publicised and interested parties had the appropriate period of time to comment upon it.
Well, can we get Eunice's response on that point?
Well, it is fairly standard practice for parties in terms of applications to respond to matters to ECU or to a planning authority which have been raised in applications. The information on which it is based on the hydrology section of the environmental statement. It sets out the parameters and it does the catchment reviews, etc. One of the things I would say about private water supplies is that inevitably there may be times when further information becomes available. And in terms of this inquiry process, the document is published. In terms of the process, you may ask for the information. In fact, you did ask for the information, probably not directly in a formal sense, but you did ask for it, and it was provided. I think there is procedures in which, if you formally asked us to lodge it, it would then form part of the inquiry record, and parties have ample opportunity to comment if they wish to in relation to that material through the inquiry process.
So I'm sorry, Mr. Innes, I'm not quite clear what you're saying. You must forgive me. I'm not terribly familiar with a lot of these aspects. Are you saying the document is part of the inquiry process or not?
It is now on the DPA website. Any party can look at it, and parties to this inquiry will be able to comment on it, analyse it, dispute it, agree with it, or whatever. The issue is also one that's going to be ventilated before the inquiry, and I think the reporter has not concluded process yet, but it's going to have, first of all, we're going to definitely have a public inquiry into private water supplies where all these issues will be fully ventilated, and parties such as yourself will be able to fully participate in that process. Equally, other parties may also come to say that they want to participate on that particular issue if they become aware of it. And this is why the reporter was also suggesting there might be other processes where parties can come along at a time which might suit them in order to participate in a process to note their concerns. But the information is now public. It's on the DPA website. It related to correspondence arising from the objection which had been submitted by South Ayrshire Council and the applicant's response to that to ECU. And ECU actively encourages applicants to engage with other parties and to give them information and responses. And we're obliged, for example, at the closure of the representation part of the case, to write a position statement to demonstrate which issues are outstanding. And the whole purpose of that process is to ensure, by the time, if there's an objection by the local authority and the papers are passed to the DPA, that it helps assist, identify issues which are outstanding and require to be canvassed and considered in the public inquiry forum. Therefore, this type of arrangement, where there is responses by an applicant, is encouraged to ensure that the issues are properly ventilated before being passed to the reporter. And the consequence of the, if I may say that, correspondence is the issue has been highlighted and the issue has been ventilated, and a specific inquiry session is to be held in relation to that matter. So the potential implications of the proposed development on private water supplies will be fully considered and properly evaluated, and that context is also being considered as we speak by the council, who have certain responsibilities for water supplies. Therefore, I think the issues arising from the paper are probably helpful in making sure that the matter is properly canvassed, the issues are properly identified, and that parties can properly participate in the process. So that's the applicant's position. I appreciate other parties may have a different view on that material, but it is intended to help identify issues and to bring focus to the particular matters which have been raised.
Thank you. Sorry, Mr. Shaw, did you? I don't want to.
Yeah, sorry. I mean, I don't wish to prolong this terribly, but it certainly does identify a number of issues which will require a response. But Mr. Hall, are you satisfied that adequate publication and adequate some promulgation, for want of a better word, of this document was made? Because I only found out about it by accident, and I'm not sure that the Mark Farm, for example, who were included in this document but not in the original environmental impact assessment, know about it to this day, and they are fundamentally affected. I'm quite happy if you say, Mr. Hall, that you're satisfied on that basis, but that was my real question. Has this been adequately publicised so that all of the relevant parties have had the opportunity to consider it and comment on it?
Well, I think I would say that it isn't unusual for further information to come forward in the course of an inquiry process or an planning application process. And that's been the case here with this information, which seems to be a desk-based study rather than new primary information, if you like. I did also notice that Mark Farm was mentioned in it for the first time. It was an additional property that was covered that was not apparently covered in the EIA report. But at the same time, no significant effects were identified. So I think the judgment would be whether the new information was so substantive as to require the further formal publicity requirements set out in the EIA regulations. I think my initial assessment is that it probably doesn't reach that bar, but certainly it is now in the public domain. All parties who have an interest in private water supplies should look at it. It will be presumably presented by the applicants as part of their evidence on this topic at the inquiry, and people can respond to it at that time.
Okay, if that's your judgment, sir, then I'm happy to accept that. Okay,
thank you. If we could move on to the only other point I suppose I had was on noise. My Ms. Crosswaite, I think you've already said that you're representing various other parties on noise, so I think you've confirmed that. And the council, I recognise the council isn't objecting on noise. I'm just wondering, Mr. Campbell, if the council would want to be involved in the noise session because of the for the council in enforcing any conditions and so on.
The council is not objecting on noise grounds, but will in all likelihood be in attendance because we want to hear what's going on. And as you say, there are conditions to be considered at the end of the inquiry into which we will have to have an input.
Yeah, okay, thank you.
Well, I'm not fielding a witness on this topic.
Can I make a comment at this point?
Yes.
Thank you, sir. Before I make this comment, Miss Spence had her hand up to speak on hydrology before we started on noise. I don't know whether you want to go back to Miss Spence first before I begin.
Well, you're holding the mic now, so we'll hear from you. But I will go. Thank you for. Apologies if I missed Miss Spence earlier. I'll certainly go back to her in due course.
Okay. Okay. Yes, myself and Mr. Grosvenor and Dr. John Yelland and also Mariana Alves will be they will be witnesses. We will be led by Melvin Grosvenor, who's listening in on this call. He's having great difficulty. He's having to listen through my phone because he cannot hear at all. He's not getting any sound from this session at all. So he's unable to speak to you at the moment. But we will be representing a number of residents in the area, and we do consider that the conditions for noise shouldn't be set until the end of the inquiry.
Thank you. Yeah, certainly dealing with, in the normal process would be that inevitably there's some discussion of can be some discussion of conditions in the course of the individual topic areas, but then we always return and have a condition session at the end of the inquiry as well, to which all parties are welcome to participate in. Ms. Banks, you had your hand up earlier.
Yes, I'm aware of quite a number of people who didn't actually make objections to this whole plan, but whose water supplies we now learn may very well be at risk. I think they should be made aware of this situation, and I think that they should be supplied with a copy of this report, because we have a list of them, and some of them are very elderly and have other problems, and I don't think it's fair that they are in ignorance of this situation. On the noise thing, I noticed that you have only put noise, and I have a problem with the vibrations from which are part of the noise, which make me very ill. I had a horrible night when I didn't sleep much last night, so I'm not feeling too great. But that is a common situation. So it's more the vibrations, and I feel that it should be clear that they are included in the noise subject.
I certainly would have no difficulty with that. I suppose the only other possibility might be to separate out vibrations into a separate session, but it might make sense to deal with it together with noise. I don't know if it's the same expert witnesses who tend to be involved in these things. Mr. Innes, do you have a view on how to deal with vibration?
Yes, it should be together, sir.
Fine, then I'll just make sure. Yeah.
Could I also comment that it's the full spectrum of noise from infrasound, low frequency, vibration, through to audible noise as well?
Okay, I've made a note of that as well, so I can clarify that in the note to the
Thank you very much.
Now, did you have any other comments from any other party about the way the topics have been grouped in Appendix 1? No? Good. Well, I think we've been going for quite a long time, turning into quite a long meeting, but I think maybe we'll have a 5-minute break there, just a comfort break, and reconvene in 5 minutes at around 25 to 12, and then we'll move on to the next item on the agenda. So I'll see you in 5 minutes. Hello, everybody. Welcome back. Hopefully people can hear me again. Before we get back into the agenda, there's a message there on the chat about the time of the meeting. Obviously, we've gone on for quite a long time. In terms of the technology, the WebEx technology will continue to run beyond 12 o'clock. But I am conscious that some people may have other commitments. So I think Mr. Nolan in particular has said he's got a hard stop at 12. Mr. Nolan, certainly at some point in the next half an hour, I'll come to you if there's anything in particular you want to contribute. But also, as I said at the beginning of the meeting, if there's aspects of what we've discussed that people want to follow up by correspondence or on email, then that's certainly possible. And things won't absolutely be set in stone in this meeting today. So hopefully not too many concerns about that. Perhaps Mr. Nolan, if you're there, is that okay, or is there a particular point you want to make now before you have to leave?
No, sir. Thank you. As long as we can submit our extra information and so forth. I think we're about to get to one of the main points, which is the point 2 of 3, which is we wanted to contribute on. But we will submit extra information, especially about some of the further details on timings and virtual versus physical, which I think we know what the opposition will be. But thank you, sir.
Okay, thank you. Now I'm conscious that I rushed to our break before really answering Ms. Spence's point about other parties who aren't currently involved in the inquiry who could potentially have an interest in private water supplies. I mean, I think, as I said earlier, my understanding of what's been produced is that it's further clarification on the information that was already present in the EIA report. It doesn't seem to me so substantive that it requires further formal publicity. There are a number of parties to the inquiry who have already raised concerns on private water supplies and can certainly use their evidence to reflect potential impacts on other people. And if other people in the area wish to help contribute to that evidence, then that would be fine. But it's not really possible for us to widen out the scope of the inquiry at this stage and start having another round of invitations for people to comment, because that stage has now passed. So if we can move on to item 4 on the agenda, which is our assessment of who's going to participate. I think I've already heard from the council and from the, yes, Mr. Nolan, sorry, you've got your hand up.
Sorry, we sort of didn't follow through the points in 3. I know we sort of did cover them and discuss them, sir, but the parties contents with the proposed form of some of these, your topics and clustering. Safe Straightening for Scotland would like to agree with Mr. Campbell that we'd like a suggest inquiry for the landscape and visual. And we'd like to be considered as a party to all of the hearings and inquiries as we have done before at other public inquiries, in the sense that, as Mr. Campbell was referring to, we coordinate a number of people, and some of the items and names, some of the names in section 2 are actually members. So Mr. Heggs, Christine and Sandy Miller, etc. So we would like to be participant in that, as we think, even though there's experts and discussion about the technical aspects which we can help with, we're also experts in the local area and our lifestyle and how that actually impacts and combines. So we'd like to be participant in all the hearings and inquiry session, and we will coordinate amongst our members to do that if that is possible. Thank you.
Yes, that's by all means. So sorry, just to clarify, that's on the landscape and visual aspect, or on all topics.
So we'd like to. So the inquiry. So I'm thirding the idea of doing an inquiry on the landscape and visual, and we'd like to be a participant in that. We'd like to be a participant in all of the hearing and inquiry sessions, apart from the aviation one. But as I said, we'll write this down and send it to you in more detail. So we don't need to discuss it in the interest of time right now. But we'll specify that just to bring the local understanding and lifestyle of that to the table. And as I said, we've participated in these forums before, so we can bring that to the table as well.
Right. Okay. Thank you. That's helpful. So yes, well, that's really what I was coming on to now, is about who wants to participate in which session. And this is really what's set out in Appendix 2 of the agenda. As I say, parties may choose to rest on that. I have the existing I've read all the existing objections from the participating parties, and so people have the opportunity of resting on their existing objection if they wish. So there's no, you don't necessarily need to be involved in every session on which you've expressed a comment. You may just wish to be involved in some of them. I think I've already heard from the council, and I'm assuming the applicant will be involved in all sessions. But if I could just run through the other parties and confirm which sessions they wish to be involved in. And Nature Scott, perhaps Mr. Jack will stop me if I'm getting this wrong, but you didn't wish to be involved in the aviation technical session, but you would be involved in landscape and visual.
That's correct, and we would also want to be involved in the conditions hearing insofar as it relates to matters connected with Nature Scott's objection.
Thank you.
I'm not sure if you're coming back to this, sir, but I think there's been some discussion from various parties in relation to what form the landscape and visual session should take with both the applicant and the council. And I think Mr. Nolan indicating that their preference would be for an inquiry session to deal with that. Yes. Just for the record, Nature Scott's preference, their witnesses indicated that she would be quite content that matters could be dealt with very efficiently in a hearing session. So perhaps that can be thrown into the mix.
Yeah, thank you for that. I'll reach a final view, but it does sound as if the balance of opinion is for an inquiry on this topic. So I think we probably are heading in that direction.
Understood.
Yeah. Okay, thank you. Glasgow Prestwick Airport, I'm assuming it would just be the technical radar mitigation session that you would be involved in, but potentially also conditions?
Yes, also conditions, and also potentially involved in aviation lighting, depending upon where you get to, sir, and in respect of the suggestion to carve out the aviation lighting. I think Prestwick's requirements in that respect would simply be to assure that an appropriate solution is adopted that meets the CAA requirements relative to structures over 150 metres in height. But I think from the discussions earlier today, I think there's a hope stroke expectation that might be capable of being dealt with without a session. But if a session is required, I think GPA would require to be involved in relation to aviation lighting as well as the radar and conditions.
Okay, thank you very much. Mr. Kelly for Bardachat and Knockdolian Estates, well, first of all, I think I did ask for any further views on the grouping of issues, but perhaps not on the form that the discussion should take. Do you have any further comments on that? And do you have any, could you tell me which particular sessions it is that you would wish to be involved in, please?
Thank you, sir. In terms of the sessions, the only change to your list relates to socioeconomics, tourism and recreation. Any evidence that I wish to give in relation to that topic is really policy evidence. So I would be putting it into a policy session. So my clients would only take part in the planning and energy policy session and the landscape and visual session. In relation to landscape and visual, it's unlikely they would wish to take part in a separate wildland session, although they would probably sit in and listen to that session. In terms of the format of proceeding, my preference would be for a hearing in relation to policy, and ideally quite late on in proceedings. In relation to landscape and visual, we will rest with whichever you decide, sir. I have no strong views as to whether it should be an inquiry or a hearing. Thank you.
Okay, thank you, Mr. Kelly. So going to the individual objectors now. Ms. Crosthwaite, I only have a note of your interest in noise. Is that correct?
Yes, but but at the moment I'm involved in Ericleoc extension inquiry, and one of the topics I'm covering there is hydrology and geohydrology. So I would actually like to be involved in that as well in this particular case, because I found out quite a lot about the hydrology of Clauchrie at the same time.
Okay, thank you.
Thank you.
Ms. Ellis.
Sorry, could I just say also conditions? Obviously, I'd like to be involved in the conditions.
Thank you.
Thank you.
Ms. Ellis.
Yes.
I've got a note of you being interested in the landscape and visual elements, and also for having a separate session on wildland, and interest in that.
Thank you. I would be interested in the landscape and visual, either hearing or inquiry, and probably not a wildland.
Thank you. Yes, Mr. Thompson, from Galloway and Southern Ayrshire Biosphere. Which topics are you interested in? You still with us, Mr. Thompson? Perhaps not. Mr. and Mrs. Miller.
Yes, we're here.
Yeah.
Yes.
Sorry, go ahead. I was just going to ask you which topics you had an interest in.
Well, certainly wildland is of importance to us here in Strayton, and the what do you call it? And landscape generally, I think, and also the impact on the dwellings within the area of that will be most badly impacted by this proposal. Mm-hmm. It won't impact our dwelling particularly because we're over the other side of the hill, but I do have an amount of sympathy for the people over there that are going to be severely impacted if this gets to go ahead. So I'd like to put my 2 pennies in.
And do you have a view on the discussion we had earlier about having a separate objector by objector session where you would just come along and give your evidence on a single occasion? Would that be preferable to you?
Presumably that's something we're talking next year. We're hoping these are going to be face to face, I would suspect.
Well, I wouldn't guarantee that, but yeah. We'll maybe come on to discuss that.
Well, some of my issues are running parallel to Save Strayton, which I am part. So probably best to follow the Save Strayton route if Mr. Nolan is happy with that.
Okay.
Yes.
Yes. Okay. I mean, perhaps while we're on this, then, I mean, Mr. Nolan, a lot of people are it seems a few parties are coming under your banner for Save Strait of Scotland.
Yes.
Is the intention for you to bring them together and bring a single coordinated piece of evidence then?
So in terms of the question you're asking about participation in sessions, yes. So for example, in the list you have Mr. Heggs and Mr. Miller and others. So some of the names that you have in Appendix 2 would collapse into Save Strait for Scotland as a party. So we coordinate that. We'd like to participate in if we're moving to a hearing on the planning and energy, participate as a party to that. Aviation, we will leave to the experts. Landscape and visual, obviously, as I said, inquiry, we'd like to be a principal party in that. Hydrology, we won't submit, but we'd like to be part of it. Noise, similarly, which is separate to Susan Crosswaith and that group, just to be clear. So we'd be party in a different way. Socioeconomics and tourism, and obviously conditions, we would absolutely want to be part of. And as I think I stated previously, we would prefer it to be an inquiry, but I understand that conditions is often done by hearings. So so they would be the parts, and we would coordinate a number of people together to do that.
Okay, so just to clarify, who on the list would come under your banner then? That's
the names that you have on this list are Glenn Heggs and Christine and Sandy Miller.
Right, okay, thank you. That helps narrow things down a little. Ms. Rofe, we haven't heard from you. Have you got a view as to which sessions you'd like to be actively involved in and supply additional evidence for? Ms. Rofe, are you still there?
Could I just comment on that? Miss Rofe isn't present here. I know she does have health issues sometimes, so maybe that's why she's not present. And I'll contact her afterwards and ask her opinion and get her to get back to you if that's okay.
Okay, thank you. I will also be circulating a note of the meeting, and we can say in that anyone who has any further views can get in touch. Thank you. Mr. and Mrs. Shaw, I think we've already established that you'll be working with Ms. Crosswaith on the noise issue, but there are other issues here that you'd wish to appear on your own behalf?
At this stage, yes, that's the case, and we'd all like conditions. Depending upon what we can arrange, I'm conscious that the fewer participants, the better. So if we can combine with other people and reduce the areas where we need to appear ourselves, then we will, of course, do that. And I will advise you as and when we're in a position to do it.
Yes, we'll come on to that shortly. I mean, it certainly would be helpful for the efficient running of the inquiry if people who are broadly of the same view could come together to give joint. Be extremely helpful. So just to clarify then, you'd wish to be involved in terms of, would you wish to be involved in the policy session?
Oh, I think so, yes.
And the landscape visual?
I think we'd like to be involved in everything with the exception of the aviation radar and lighting, because all of the other sections are very relevant to us. We're very close to this development, and we're anticipating that it will have a significant effect on us. I would also have nothing constructive to say on forestry, but in respect of the other aspect, I would like to be involved. We would both like to be involved.
Okay, thank you very much. Ms. Spence, can I turn to you now? Which sessions are you expecting or wishing to be actively involved in?
The landscape and visual, and particularly residential amenity, which is included in that at the moment on this list. I may want to be involved in the hydrology because I'm told that my premises are at risk too. And noise, including vibration, and also the socioeconomics, but this access, traffic and transport and that sort of thing, I've also made an objection because of the mess that occurred during the construction of Kilgalleack. And I'd also like to be involved in the conditions.
Okay, fine. So the access and traffic we're dealing with by written representations at the moment.
Yes, but more from the effect on the community.
Yeah, there's still an opportunity to make further comments in that area. Yeah. Okay, Nikki Spinks, if I could turn to you, if you're still with us, and ask you which of the sessions you'd like to be actively involved in going forward.
Well, you've got me down in most of the sessions, and those are the ones that I'd like to be actively involved in, and
okay.
as well as conditions. But I probably will join with Chris Shaw on that one.
Okay, thank you. And then we had Joy Kendall, I think, as a party that wasn't on my list.
Yes, that's right.
Yes.
So the ones I'd like to be involved in are planning and energy policy, landscape and visual, hydrology, ecology, noise, access, socioeconomics, health and safety, and conditions. And like others, I may join with to represent.
Good, thank you very much.
Thank you.
Right, now Mountaineering Scotland, I don't know if they have Mountaineering Scotland now. There was a suggestion that they also wish to take part in the inquiry, but weren't included on my list. I don't know if they've now joined the meeting.
I don't think they were going to join the meeting, sir. I think they just intimated through Mr. Kelly that they wish to take part.
Right.
They're former clients of mine and quite efficient. And I think if they were notified of the outcome of this meeting, they would react accordingly.
Okay, thank you. I think there was some message from Graham Mason, our host, that they were maybe attempting to join the meeting, but if they're not here, that's...
They have been sent the link to join the meeting if they so wish. Laura has sent that on one of the case officer.
Okay, well, they don't seem to be with us as yet, but they can make their position clear in correspondence. Okay, then. Now we've touched on this issue of parties grouping together to make a joint case. I mean, certainly this does make the running of the inquiry much more straightforward. And as I say, it's really not helpful for me to hear the same arguments being made by different people. And of course, you can still have a joint group, but still call on different individual witnesses to make different aspects of a case. And normally it is people from the local community who do join together in this way, and that's worked really well in other inquiries. So I would encourage people in the local area to get in touch with each other and try and coordinate themselves. No compulsion to do it, but it really would be very helpful for a lot of aspects of the inquiry, especially in a case like this, where we do have quite a lot of participants wishing to take part. Does anybody have any further points to make under agenda item 4? Okay, I'm not seeing anyone with their hands up, so we'll move on to item 5 and talk about the order of the topics. So I've set out a provisional order in Appendix 1. So I know, Mr. Kelly, you have a view about the position of the policy section in any order. I suppose my feeling is that it would set the context for what we go on to talk about later, but do you want to make a case for policy being heard later in the inquiry?
Yes, it is my experience that it is better if policy is taken near the end of proceedings. I take a very simple point to illustrate this from Glen Sherrill. One of the longest parts of the debate on policy arose directly, they had a hearing there, arose directly from answers given in cross-examination by the landscape and visual impact witnesses. If you take policy first, then it's not possible to adjust or reflect the detail of the evidence in the policy conclusions, which can then be referenced in the hearing. So my preference is for the submission of a fully detailed hearing statement, followed by a hearing session on policy held quite late in the process.
Thank you. While you're on, do you have any other comments to make on the potential order of the issues?
No, that is my only concern over the orders for the hearing session on policy.
Okay, thank you. If I could turn to Mr. Innes then, first to address that point about policy, but also any other matters about the order that we consider these issues.
Yes, in terms of the order, I think probably the only comment we'd make is that we think aviation should go to the absolute tail of the topics. It's likely, as I say, the one that we are still working our way through with the airport, and I think, as you've indicated, we're getting an update mid-February. So that's the topic I would put last. Planning policy is a difficult one because there is the element of it does set the scene, but on the other hand, it can't pick up evidence. But there is another way of picking up evidence, and that is that closing submissions cover all the evidence at the inquiry, and that's why we have a closing submission, is for the parties to be able to pool their position together, having heard all the evidence. So if something does emerge, then it can be part of the closing submission in relation to matters. So I don't think we have particularly strong feelings about the policy session. Quite a lot of it. Yeah, I mean, there is benefits in having it up front and setting the context of quite a lot of the other topics, but equally, I don't think if it happens near the end, it's a particular problem. So those are my only issues on the general matter regarding the timetabling. As regards, as we'll probably come on to availability, we have limited issues, but we have 2 or 3 issues on timetabling that we have. But apart from that, we probably wait to deal with timetabling. But on structure, just those matters. And I think it would be sensible to probably deal with the landscape and visual and wildland in an order together, so that one followed the other. There's a certain logic in wildland following on from the background to the landscape and visual. It's a subset but different, and it would make sense to have a break and then go on to wildland and deal with it as that separate topic session. But it might be sensible to timetable that because similar witnesses will be involved. Apart from that, most of the topics are fairly distinct, and therefore it's not a question of which party. So in terms of the applicant, we would be quite flexible in relation to those other topic hearings, and it may be other parties have preferences for how they're arranged relative to the parts that they wish to attend. So I don't think I've got anything to add apart from that. Thank you.
Just confirm on the aviation and having the aviation session near the air, only in relation to radar mitigation, or it seems to be a lighting issue that is before the landscape issue when we're talking about landscape.
Yeah, so hopefully with the update at the beginning of next year, that wouldn't necessarily be a session. It might well be that it's a discussion on the nature of a condition to be imposed. But if there were to be a lighting session, then yes, it should be in front of the landscape and visual and the wildland session, because it would have a bearing on both.
We'll have a view on the session, particularly this matter of when to hold the policy session.
Sorry, are you asking me, sir?
Yes, please.
I've heard Mr. Kelly argue before for bringing policy to the end of the inquiry. We are, I think, broadly neutral on this matter, but on balance, I prefer what Mr. Kelly says. But just on balance, I think it doesn't matter. You can pick up evidence, of course, in a closing submission. Mr. Innes is quite right, but you can't cross-examine on it. And so if the policy session is at the end, you can do that cross-examination. But it's a fine balance. Otherwise, we have nothing to say about the order that's proposed. We'll just leave that to you entirely.
Thank you very much. I haven't got a strong view on when the policy happens either. So if there's who has a strong feeling to be at the end, then I think I'm happy to accommodate that. So do that and move policy down to the end. Unless anyone else has comments to make. Any other party got comment to make about the ordering of the issues when we come to have the inquiry?
So if I could jump in for Nature Scott to reflect the comments that Mr. Innes made in relation to landscape and visual, reflecting the discussion earlier, Nature Scott would be very keen to have separation of the topic of impact on wild land in the landscape and visual session and have specific timetabling in relation to that. It wouldn't be Nature Scott's intention, excuse me, to take part in issues out with that particular element of the topic, and so having some sort of delineation would be really helpful.
That's fine. I mean, I think so what Mr. about the general landscape and visual set the context, and then immediately afterwards going into the wildland session. So it probably would be helpful for Nature Scott to at least attend the landscape and visual session to hear what's being said, and then that would help give the, because that will be part of the context for the discussion going forward into the wildland session, and again to avoid sort of repetition.
Noted.
Thank you. Any other comments on ordering?
Sir, just to say on behalf of Glasgow Prestwick Airport that we'd be content with what Mr. Innes has suggested relative to having the mitigation aspect of aviation put towards the end of proceedings.
Thank you. Anybody else? On to item 6 and the knotty issue of dates, in particular and duration. Perhaps we should deal first with the possible duration for the inquiry, so we know how much time we need to set aside. I know it's hard to know at this stage how long parties envisage it taking to present their cases. We've got a lot of individual objectors in this case, which could potentially take a lot of time, but hopefully people can group together and present joint cases there. So much will depend on that. And also, we don't know at this stage whether it will be a virtual inquiry or an in-person inquiry. Pretty fruitless to speculate on that really at this stage. Probably needs to come. But if it were to be a virtual inquiry, we might need a bit more time to deal with the sort of technicalities. And I think you're working online as well, so we probably need to have more breaks. So if I could just ask for, well, perhaps more the people who've got the most experience in inquiries, the appellant, Mr. Innes, and the counsel, and Mr. Kelly. We might need in total for the inquiry.
So I'm afraid you're breaking up again and not really audible. I don't know what's gone wrong, but it's not possible to hear what you're saying.
Oh dear, can you hear me now?
That's perfect now.
Right, sorry, I was seeking views on the potential overall duration of the inquiry. Particular of you, Mr. Campbell and Mr. Kelly, most experienced in the feel for how long the inquiry might take. And I was asking Mr. Innes in particular to start off the discussion here.
I think this needs to be quite carefully handled, and the reason being that if we're in a virtual world, I have now done quite a lot of virtual world work, and I think the number one issue is trying to take on more than you can deal with in a day. And the trouble with it is that once you start the process, you've almost hit deadlines and having to keep things going because some people are not joining in the following day because it's not their session. So I think realism is the number one thing about how long things take virtually. And equally, it is important that if we're going to have oral procedure, that it's done effectively and properly, and that everyone has a proper opportunity to participate. And the difficulty is that if you don't set enough time, what happens? We all end up rushing, and I think it leads to more pressure in the day for people, and I think that can be a bit unfortunate. And it can also mean that some parties who perhaps were rushed in a particular session feel they didn't get a fair opportunity to participate. So I think the key thing is if it's virtual, making sure that we have adequate time in terms of dealing with matters, an adequate process to make sure that we can hopefully deal with the technical challenges that will undoubtedly still exist in that format, but also keeping a sensible program, and that's the balance that needs to be struck. So normally a policy session might last round the table a morning or whatever. It will last a day virtually at least, and that's the problem, is that if you have large numbers of participating in that session, it might last more than a day, because by the time you've gone round on, say, a couple of questions, that's the morning gone, and a couple of questions in the afternoon. It takes time. By the time people have come off, perhaps had to come on, catch up or whatever. That's the experience, is that virtually, particularly in hearings and large participation, adequate time needs to be given to ensure that everyone's given time. Insofar as, so that would be, for example, I think planning would take a day at least in terms of the format and the numbers of people that want to participate. Aviation I'll leave to last. Landscape and visual again has a number of expert witnesses and cross-examination by a large number of parties. That looks to me like a week's work on the landscape and visual and the wild land potentially, just with the number of parties that might be interested. So you might suggest 3 days, or 3 days for the landscape and visual and 2 for the wild land. We then move on to, I think, more focused technical issues. I should think hydrology would last perhaps a day and a half in a public format, and noise might last up to 2 days in a public inquiry format, given the nature of these matters. And finally, probably conditions again. Just the number of parties, that's at least a morning, perhaps stretching into by the time we've discussed all the conditions. It could even last a day. And my final one was aviation. If that ends up a public inquiry, my experience of these matters is to take a long time because there are technical issues and, I say, the various other issues that are associated with it. And I suspect that's probably more potentially a week or more purely on the aviation matters, because just the nature of the number of topics and the complexity of the examination of those. That's an overview. And I think in terms of a virtual world, as I say, I think the key thing is making sure there's adequate time, particularly in hearing sessions with large numbers of participants and inquiries, for everyone to have a fair opportunity to participate. And I think that's the problem. If we don't allocate sufficient time, that's the problem. Is that once you set the process, if it's a topic-based inquiry, you have to keep to the topics, because it's not fair on people that are only coming for the particular topics. So it puts a pressure on completing it within the timetable. So I think it's being realistic about timetables, and then affording appropriate time for each of them. I would say that in terms of timings, I mean, I've been doing hearings that have been lasting up to 6 hours virtually, and I think that's quite a tall ask, just in terms of time. I think the realistic timing is probably about 2.5 to 2 3/4 in the morning, and 2 to 2 3/4 in an afternoon. Just in terms of there is an additional, I think, concentration issue with the online formats and the technologies that make it harder. And I think that needs to be borne in mind when timetabling if it's going to be virtual. And I think the other point about this is that I suspect that at the current time, planning for a virtual procedure is probably likely to be more realistic in the timescale than not, because I think there is a very real possibility that we will not be fully back to being able to meet large numbers of people by the timescale of this proposed procedures.
Okay, thank you, Mr. Innes. That's very helpful. I take on board a lot of what you say. The prospect of a week discussing aviation issues is a joy to me, I must say. Mr. Campbell, do you echo what Mr. Innes has said?
Almost entirely, although I think in firm hands, he's a little pessimistic. People will have lodged either hearing statements or inquiry statements or precognitions or a combination of those. And so we know what people are going to say. And so if you are a firm chairman, and I'm sure you will be, I think we can do a little bit better than what Mr. Innes is suggesting. But people have to be given a fair chance to say everything they need. And so overestimation should be your watchword. I don't know if you're asking for a view at this stage about how long each session would take, but I certainly agree with what Mr. Innes says in relation to planning policy. My own feeling is that landscape is 4 days, not a week, but it can, as we know, landscape and visual can go on. And the council doesn't have an interest in hydrology, probably a day and a half. In the end of the day, it's a pretty narrow issue, and is already well defined in the paperwork, and that refinement should continue. But people have to be encouraged to get on with it, to speak up and be brief. And if that sounds a little regimental, it's not meant to, but I do think that this medium for inquiries tends to encourage verbosity, and I'm sure you won't allow that, sir.
I'll certainly try my best. No, that's helpful. I mean, I think that having one advantage of a virtual process, in some ways, is that it can be spread out a little bit more, because people aren't all having to travel to a particular place and book hotels and that sort of thing.
Right.
So in that way, that is one way it's slightly easier. Mr. Kelly, I just come to you particularly because you've got a lot of experience of inquiries, but both to ask you about the overall, to reflect on what Mr. Campbell and Mr. Innes have said, and also to give your judgment on the number of days required for the various sessions.
Thank you, sir. I would agree with what Mr. Innes has said in terms of the length of the sessions and the need to plan. For Glen Sherrill, we found that the daily sessions were quite tiring. We probably hadn't allocated enough time and therefore there was pressure to run on. And I'd agree with Mr. Innes that having sat through a number of 6-hour-plus days in virtual inquiries, it is very, very tiring indeed. So I think we need to just build that into the programming. But basically, my view accords 100% with what Mr. Innes has said.
Okay, thank you very much. So on the face of that, particularly if aviation was going to remain an issue, we'd be looking at potentially maybe a 3-week inquiry, around about 3 weeks, or longer if we didn't sit on a Monday, which normal practice is that we don't sit on a Monday, so we might even be going into a 4th week. Before we go on to talking about availability, does anybody else have any comments on what they've heard from the legal voices in the virtual room about the overall time that might be required?
I think, sir, if I may, in relation to the aviation matters, I think the only observation I'd make is that if we're required to go through every technical aspect, then I agree that a considerable period of time will be required. But I would say that I would hope and anticipate that there ought to be significant scope for agreement on the technical issues. I can't see it being seriously disputed, for instance, that a wind farm creates clutter which requires to be mitigated. So, while if every technical aspect requires to be gone through, aviation is going to take some time to go through, I would hope there would be considerable scope for narrowing of the issues in accordance with parties' obligations in terms of the code of practice.
Okay, thank you for that. Anybody else?
If I may chip in on behalf of Nature Scott, in relation to the landscape and visual session, I think Nature Scott had anticipated or hoped that the wildland impact element might be capable of being dealt with within 1 day rather than the 2 days that Mr. Innes had indicated. But having heard this morning of the number of individual objectors who have indicated an intention to contribute on that topic, that assessment may require to go up to the 2 days that Mr. Innes had indicated. And again, just from experience in the Blargar wind farm inquiry, which was the first fully virtual one to be held, I would absolutely concur with the experience of Mr. Innes and Mr. Kelly in relation to not underestimating the how tiring it is to take part in a 6-hour day in a virtual world. It is somehow more tiring and requires a concentration of a slightly different form to deal with all of the technical issues and looking at multiple computer screens and managing documents across them, etc. So I would echo the need to build that in as a factor, particularly if we're looking at a lengthy inquiry as we seem to be in this instance.
Okay, thank you for that. Ms. Spence, you've got your hand up.
This subject of aviation should be covered equally by the Clay inquiry, because the same principles would apply to both, and presumably the evidence should be in that inquiry and should be quick to give again. And if a decision is made on this at that inquiry, the same decision would be required for the Clauchrie inquiry, because it's exactly the same area that we're discussing. If it's going to fail on one, it'll fail on the other.
Yes, I mean, I confess I haven't got into the depths of all the technicalities of the issues on radar mitigation. Certainly, evidence would have to be presented to this inquiry. I can't adopt conclusions from other inquiries without having seen the evidence myself. But yes, I agree that it probably is the case that once issues have been rehearsed in other inquiries, then you'd hope it would speed things up ours, because experience especially if the same witnesses are involved, can then be brought to bear in our case. Mr. Miller.
Hello again, sir. Yes, my point was specifically technical. As a person with 30 years of IT developing systems, I can say that I would back up Mr. Ennis's initial observations on the technical issues of running a meeting such as this. We've had 2 router outages, and I've just had a few minutes of not being able to respond to any of the clicks I've been doing on the screen. So there are significant issues. I hate to be a harbinger of bad news like that, but it is something that we need to be aware of. Thank you very much.
Yes, well, I think we've experienced that today, haven't we? I've certainly experienced it, the difficulties that are inherent, but we just have to do the best we can, I think, in the current climate, and it is incumbent on us all to make sure that we've got the necessary bandwidth and so on to participate in the sessions.
Unfortunately, people like myself who live in the remote areas, we're hindered by the capacity of the telephone lines. We have, as I said earlier, 5 megabytes of bandwidth generally. Sometimes it drops off down to 4 or 3. Sometimes there might be an engineer who's had to plug something in and out of our local exchange, and all that gives interruptions and slowdown. So we are a little bit hamstrung on this in this aspect. Thank you anyway.
Yes, I do appreciate it. I suppose the opportunity does always exist to give written evidence if it is proving impossible to communicate through these means. Anybody else before we get on to actually discussing times? Mr. Grosvenor.
Yeah, the suggestion has been 2 days on noise. Obviously, the noise came clear. We agreed 2 days, but given the comments made just now, I'm concerned that for Clauchrie, 2 days, given that there are more witnesses coming forward for Clauchrie, I've got my reservations as to whether 2 days would be sufficient.
Okay, thank you for that. Might be worth building in a bit of flexibility there then. I mean, one approach that we can take, if everyone can be quite flexible about their timing, is that we can build in extra days for overspill. So one could say every Friday was a day for overspill, and then people would keep their availability for that day, for instance, would be one approach. And anybody else on this? Okay, well, if we come on to actual availability then, initially I asked about availability the 12th of April, mid-May, and then I think in a subsequent email following a comment from Mr. Kelly, we extended that to the 4th of June. And then I noted the comments from Ms. Crosthwaite as well about lack of availability at the end of May and early June. And then another constraint potentially is the dates of our CLEOC inquiry, which I understand is meant to finish on the 10th of February. And we need, I think we are understanding of the desirability of having something of a gap between the end of our CLEOC and the beginning of Clauchrie. And that's where the 12th of April date came from, giving an 8-week plus gap as a minimum there. So certainly it is the DPA's intention to accommodate as many parties' availability as possible, but with a large number of parties, that can get quite difficult. And we do also need to manage our caseload efficiently and be fair to the applicant in terms of progressing their application, whether it's to an approval or a refusal ultimately. I'm very conscious that this isn't the day job for private objectors, but we do need to appreciate that inquiries can involve substantial time commitments, and so there may be pressures in terms of the lead-in to inquiries in terms of meeting deadlines and so So if it's a question of individual witnesses or advocates not being available at particular times, then, you know, in theory, there is always the possibility of finding alternatives there. In terms of my only thought myself, in terms of certainly Ms. Crosthwaite's concern, was that on the noise issue, we can potentially hold that later, and other issues out of the way earlier, possibly. I certainly wouldn't want to run the risk of running into school holidays in July next year, and the 6-month delay now seems excessive. So those are my initial thoughts. Mr. Innes, if I could come to you first for the applicants' availability and thoughts about how we can accommodate the differing concerns of different parties.
I think starting off with, I think all inquiries need a decent run-in terms of preparation and prior notice. And whilst we may be fixing dates for actual procedures, we do acknowledge that there's quite a lot of work that goes into prior to that in statements of case and hearing statements, etc. So we are mindful of the fact that certain of the objectors are common to another project, which is obviously currently going through the inquiry process, and recognise that it is appropriate to have some sort of gap. That said, we were certainly looking, having acknowledged that, to make progress in May. And as far as our problems of availability are concerned, it primarily relates to landscape and visual witnesses. And given who's involved, I suspect that quite a lot of the same dates may be problematic for the respective witnesses. So in terms of landscape and visual being the key constraint, we've got good availability the last week in April, first week in May, problem with the 10th of May, good on the 17th and 24th, not good on the 31st and the 7th of June, and then clear from the 14th of June onwards. So as I say, 26th, 23rd, 26th April, 3rd May, good. 17th, 24th, good. 31st and 7th, not good, but clear after that. And in terms of other dates, there's a problem on the week commencing the 14th with me. And that's it as far as our constraints are concerned.
So that's the 14th of June?
Yes.
Midsummer's Eve party.
Okay. Right, Mr. Campbell.
Yes, sir. I'm advised that our landscape advisor is not available before the week commencing the 24th of May. That doesn't mean you shouldn't start with other material before that, but we would be obliged if you could not schedule the landscape session before that week. That's the only inhibition that I've been informed of.
Right, okay. Mr. Innes, your dates that you were mentioning, apart from your lack of availability since 14th of June, those dates were also to do with landscape and visual, is that right?
Yes, so that's the only issue that we have in terms of availability. So looks like the 24th looks like a starting point for a possible week.
Okay.
I was just going to add one point, so that we, in other proceedings that I've been involved with, they have they've set dummy days behind the main set of, so for example, if we, just hypothetically, if we started the landscape on the 24th and perhaps run it 2 days landscape and visual, 2 days wildland or whatever, that the Fridays are carryover for either day relative to technology problems or whatever that might occur. we haven't had to use them, but I mean, it is a reasonable thing to do to have within a week, to make some accommodation, and that's sort of how it's been done elsewhere. But that might be a way of dealing with, some of these issues, is to say, well, actually, it's 4 days or whatever, and the 5th day is the hangover in terms of if there are any issues or we need we haven't quite finished.
Yeah, I think that's very cool. Yeah. Turning to Nature Scott then, and Ms. Jack.
Thank you. In terms of landscape and visual, as you're aware from what Mr. Campbell said earlier, the Council and Nature Scott would be sharing a witness in relation to this session. My understanding also from the witness is that availability would commence on the 24th of May, but I have been told additionally that there was a holiday booked for week commencing 31st May. So if there were to be any potential for run over into that following week, that would cause a difficulty. But as long as we anticipate that we'll finish within that week of the 24th of May, then that should be fine from our perspective.
And is that an issue with the wildland witness?
So if there's any broader difficulty and we need to start later, I'm told that from the 7th of June onwards, the witness and those inputting from the Nature Scott team would all be available. So either week commencing 24th May or 7th June onwards for us.
But potentially in that week of 24th May, we talked about having the wildland session after the general landscape and visual session, but that might be an argument to have wildland first. And then we'd be sure.
It's the same witness who would be speaking to wildland and the broader issues on behalf of the council. So, so long as all landscape and visual matters could be dealt with within that week of the 24th of May, I think that would be fine.
Okay, thank you for that. Mr. Blythe, for Glasgow Prestwick, do you have any availability issues in?
The only thing I would need to flag, sir, is that I, as matters stand, am due to be in Canada on business from the 23rd of June onwards for about a week or so. But I think it's anybody's guess as to whether that will be actually achievable. But if we're starting on the 24th of May, I suspect there's some scope for being done and dusted by then. So that's the only thing I would flag. That would take me out from about the 23rd of June until about the 30th of June.
Yeah, I mean, we talked about the aviation session being towards the end, didn't we? So I guess we would be looking at some time in maybe the second week in June.
Yeah.
Probably where we're looking. Yeah. Okay, Mr. Kelly, your availability.
Thank you, sir. The Strathy Wood inquiry, as I've indicated, is sitting for the whole of the week beginning 26 April. But just checking my diary, I don't have any restrictions for May and June at the moment. So, and it looks as though we're talking about avoiding that Strathy Wood week. So really, I can fit in with anyone else's availability after that.
Okay, thank you very much. So, Ms. Crosthwaite, then, understand your limitations. I mean, the issue about noise. Well, I suppose how firm is your lack of availability, and what about this idea of having noise as a separate session later on?
Yes, I'm not adverse to having noise later on. I'm not going to be in the country between the middle of May and the middle of June, so I'm not going to be available at all until after the 16th of June. I would like to be involved in the hydrology as well, but again, I can probably do quite a lot of work on that beforehand and leave it with other interested parties. But certainly, I need to be there for the noise sessions. The other thing that I think we should all consider is that by May and June, hopefully, we'll be able to have face-to-face inquiries. I mean, you know, I really. The summer should sort this out once and for all.
Well, but we've all said that 6 months ago, didn't we? I don't know if it's wise to make too many predictions. I mean, I suppose I was wondering. I mean, when you say you're going to be out of the country, if we were virtual, would you be able to take part in the virtual inquiry from abroad, or I mean, I wouldn't want to impose on your holidays if that's.
No, it won't be possible to take part during that time.
Okay, thank you. Fine. So potentially, maybe if I could come back to Mr. Innes for the idea of having a noise session sometime after the 16th of June. Would that be acceptable to the applicant?
Well, I think with all these proceedings, one of the watchword is flexibility, in the sense of it's not like we are all in a hotel and booked hotel accommodation. It's likely to be virtual, and in those circumstances, that we'll have to fit in with perhaps fitting a separate session in on noise. And I've already told you that the week commencing the 14th of June problematic for me, but if it was slightly later, fine. But I don't see anything inherently wrong with having the noise session slightly later to accommodate that.
Okay, thank you for that. I mean, I suppose once the inquiry, if we have a slight break and have a later session, it's not necessarily delaying the final report by myself, because I can start working on the aspects that I have already heard. So maybe if I could just, rather than going through everybody individually, if we are potentially looking at starting on the 24th of May, and then running into early June, does anybody else have any prior commitments for that period? Mr. Miller.
Yeah, the only point that I would like to make was that we have sometimes requirements to take time out to visit hospitals. Mrs. Miller suffers from cancer, and we had a telephone call the other day for an appointment that came up for the 22nd of December. So we might get short-term call-outs like that. Now, obviously, we'll have to make those a priority, but obviously we can fit ourselves round whatever may need to be filled in if it happens to clash with something. I could possibly get a new fancy phone, but where we are now, we don't have fancy phones because we have no phone signals, which is why we're on landlines here. So we could work around a phone conversation if necessary, but it's not likely to happen that often. Often the appointments are scheduled ahead of time. Of late, of course, sometimes they've been a bit interrupted, or not happening altogether, but it's an ongoing issue we're working with, and I just thought I'd raise it as it's not necessarily going to interfere with anything, but it's something that could crop up if a consultant says you've got to have a scan on a certain day, as has happened recently. So thank you very much, sir.
Okay, thank you. And certainly we can try and be as accommodating as we can should those circumstances arise.
Thank you very much, sir.
Okay, then, if nobody else wants to speak on that, then I'll draw up a preliminary timetable based on a start around the 24th of May, and I can circulate that with the agenda, and if people have further comments, they can come back to me subsequently. I think inevitably these things will probably change as we go forward. So, conscious of time again, if we can move on to item 7, the procedures. I mean, I can set out a lot of this and exactly describe the various documentation that would be required at the various stages in my notes of the meeting. As I say, traditionally there's been, or normally, normal circumstances, there might be around an 8-week lead-in time, but I think the experience has been with virtual procedures that a little more slack is useful in the system. So I think I would propose breathing those timescales out a little bit. If I can just quickly run through what our normal expectations would be for inquiry sessions. There is the first stage is the production by parties of inquiry statements, which are short papers that provide the heads of terms of the main elements of the case that will be put forward, that list the documents that will be referred to and the witnesses that will be giving evidence. And normally we'd be seeking those around ahead of the start date, but as I say, maybe we could, and especially given the amount of time we have, that we could maybe push that up to 10 weeks. And then the second stage with inquiry sessions is for the submission of precognitions, which are the detailed statements of evidence that will be read by each witness on the day, no more than 2,000 words long. Normally we'd be seeking those 2 weeks in advance of the inquiry, but perhaps we could push that out to 3 weeks. And then for hearings, we seek a hearing statement from each party, setting out full details of the case that will be put forward, again listing the documents that will be referred to and the witnesses that will speak. Normally we'd look at 6 weeks, but we could perhaps push that out to 7. And then on the basis of that, I would prepare an agenda, which I would circulate normally 2 weeks ahead of the hearing session, but I could try and do that earlier again, do that, give people 3 weeks notice. And then finally, further written submissions for those topics that we're not having a physical session. Normally it would be 6 weeks, but we could go for 8 weeks for further written submissions. But in some ways, that's less critical. But perhaps more critical is that with further written submissions, there's then an opportunity for the other side to respond. And normally people are given 14 days. But perhaps in the current circumstances, we could move that up to 21 days. So, Mr. Innes, do those timescales sound suitable to you?
Yes, sir, they do. We tried previously to perhaps, in the virtual world, bring things more to a head with having more of an exchange up front. And I think with the benefit of hindsight, it may have caused more confusion than benefit. I think the key in any of these procedures is the inquiry note sets out in very clear terms exactly what's expected of everyone at the various stages, because I think there has been some confusion in some of the other proceedings that have been involved with, and that makes it hard for people to understand exactly what's required by certain dates. Certainly my understanding that absolutely reflects it. I think the one thing that is important, that if we're going to have public inquiry sessions, there must be fair notice of the case being made, and that the inquiry statement of case is important in the sense of the purpose of an inquiry procedure is not to suddenly be hijacked with something in a precondition that hasn't been foreshadowed. And I think fair notice is an important part of procedures, given that the preparation in the current circumstances is less than straightforward than it might have been before when we could all meet up and everything. So in terms of that, I think it's sensible to make those timescales slightly longer, to give more people more time between them, and equally, hopefully, the pre-examination meeting note will set out in quite simple terms what's expected of everyone at the various stages, and then it will be relatively straightforward to meet everything. But apart from that, I have nothing further to add on that point. Thank you.
Okay, thank you. That's all noted. Mr. Campbell, do you consent with all that?
Yes, thank you. I have nothing to add to that at all.
Okay, so does anybody else have any comments on timescales for submission of papers? I can set out, as Mr. Innes has indicated, exactly what is meant by all these terms like recognitions and so on in the note of the meeting. So, given the time, I think we'll move on if we can, unless anybody's got any comments. Okay, documents, a word about them. Important that all documents are submitted in advance for hearing and inquiry sessions. Normally that would be 4 weeks ahead, but in this case we can push that out maybe to 6 weeks. It would be extremely helpful if the applicants and the council could liaise in producing an early list of documents and decide on who should produce what. So in this way, there should be no need for several parties to submit the same documents. So normally what we'd have is this list of core documents, which would be all the main things that people would expect to see. So there's no need for individual parties to submit documents about sort of national energy policy and things like that, because they would all be on this core document list. So the only individual documents that individual parties should need to produce would be things that are very particular to their case. So yes, if I could ask Mr. Innes if he would be prepared to take the lead on drawing up a core document list in liaison with the council.
Absolutely, sir. I'd be delighted to do that. I think there's one thing which I would say I think we have got into a bit of not a difficulty, but it's been a bit challenging at Clauchrie in relation to document numbering. And I think that's been a bit problematic because everyone's using a CD number, and every document is a CD number, and almost has to be allocated a CD number before it starts. And I just wonder whether we could perhaps take this away, and that all inquiry participants are given a document reference number, such as we might be applicant APP, and that everyone's given one, and then they're in control of their own document numbers. So when they're preparing their evidence, they know the document numbers, etc. And one of the problems about leaving document referencing to a date is that in a hearing statement, you might be lodging documents and a hearing statement, and we don't know what the numbering is. So I think that's been challenging, and I think we could come up with a system that is much simpler for everybody to work, and everyone would be given essentially an affix for their own documents. And that would probably mean that people wouldn't have to be looking for other people to give them a number. And in that context, again, we've been working a document hub. It's quite hard work, but in a virtual world, probably pretty essential. So again, we'd be potentially looking to work with DPA to provide that, and to see what improvements we can make on from our experience in working with other sessions and other inquiries, to see if we can make it better and more user friendly. I think one of the problems with hubs is, I'll just highlight one example. Everyone's given a password to access the hub. The hub actually generates personal passwords that can't be known to anybody else. So if you get a 0 and a 0, it can be a bit difficult for some to work out, and it almost requires a copy and a paste to get in. Now, there's lots of ways that we can make access and advice as to how to get into the hub more effective, probably, and that's something again that we could look to build into this process as essentially a lessons learned experience. So certainly we're working in this sort of new virtual world, and we're trying to make improvements, but there's something that I think we could take away and perhaps improves the ability to access all parts of the inquiry process more effectively for all, and make it simple. So that's something that we could perhaps take away and work with the DPA over, and we could perhaps bring some of the lessons to that process, and it perhaps could form part of a follow-up to the pre-examination note of how to lodge documents. It could perhaps be a separate to that, so that everyone's clear as to what's expected and how they can access information and lodge information in as simple a way as possible, and people don't feel in any way confused or finding it difficult, because I think that's been a problem in other procedures. So that's my one take on that, and we'd be happy to work with the council, DPA and others to make that better and to make it easier for people to work in the system.
Okay, I'm not averse to that. So this would be a list, not just of core documents, but potentially all documents that would go in there, and people would be able to insert their documents, any documents wished, into the system. I'm all in favour of things being simple and easy to use, but yeah, talk of logging in and passwords and stuff makes things sound more complicated in some ways. But you're right that there probably is potential here to do something. So I'm happy to, without wanting to be necessarily a guinea pig, I'm happy to trial this system if other parties are happy. Mr. Campbell, do you have any comments to make on documents?
No, the experience in the other case has been that Shepherd and Wedderburn's hub has been very beneficial, except for old people like me who forget their passwords. But it seems to work well, and obviously it can be improved all the time. So we're grateful to them for that. Otherwise, I have no comment.
Right. Thank you. Does anybody else have any comments? I'm happy to go with Mr. Innes's suggestion that we maybe follow up the note of this meeting with a later note about giving more detail on documents and how documents should be submitted and input into the system a little bit later on. Any other comments on documents from anybody?
If I chip in, perhaps just from experience from Largar, we worked virtually. What worked very well in that session, and I appreciate that it might not work in every circumstance, was that we actually had all of the documents on a document list, so that there was only ever one list that required to be referred to, and that worked very well. And it may be that some hybrids could be developed whereby people would be given a prefix that could be used, but everything could ultimately end up being amalgamated into one list so that people knew where to look for any given document. But it's perhaps something that we can have further discussions about offline, and then feedback in through Mr. Innes as to what the outcome of those discussions might be in terms of what the most user-friendly way forward might be here.
Yes, that doesn't sound incompatible with what Mr. Innes was proposing. Something else. I think somebody's got there. If somebody could mute themselves, there's a bit of interference on the line. Thank you. If we can move on to agreed statements. In many inquiries, it's been useful to have some statements of agreement on certain matters, such as perhaps the policy position, policy update. Mr. Innes again, is there scope in this inquiry for some agreed statements to be prepared? And if so, what's on?
Well, I think there is always benefit. I think certainly policy, we can probably work with the council to get a list of what's the most relevant and identify particular passages that perhaps are most relevant. Interpretation, of course, is always another matter. There may well be possibility on landscape and visual matters for certain matters to be agreed in terms of baseline, etc. And also, if we end up with technical aviation matters, there may well be statements of agreed matters. They're all, I think the key thing is finding out whether there'll be advantage or not. And sometimes when actually parties' representations are quite focused already, actually the differences between the parties is actually relatively apparent. And actually writing our differences are quite narrow, doesn't get you much further, but it can help in establishing the baseline. We are working with other parties at other inquiries to do that. We would just seek to do that again. And just coming on to conditions, we would certainly be working with the council to produce a set of conditions that can then be circulated to other parties for comment through yourself.
Yes, it's probably useful to deal with conditions under the same heading. Yeah. That certainly would be helpful. And again, I'll probably set date for those to be lodged, maybe 8 weeks ahead of the inquiry or something. But what is useful with the lists of proposed conditions is that I imagine it's unlikely that you'll reach full agreement with the council on all conditions, and any other parties who might be involved in that discussion, such as Nature Scott. So it's helpful to have it tabulated where if there are alternative wordings for conditions or comments or the applicant's suggested conditions and the council's comments side by side, that's a very helpful format for it to be submitted in. Okay, well, I think on the agreed statements, I probably won't specify those at this stage, but just encourage parties to seek opportunities to produce those for those examples where that would be helpful. Mr. Campbell, do you have any comments on these topics? And anyone else?
No, thank you, I don't.
Okay, thank you. Finally, on this item, closing submissions, just for those who aren't aware of these, at the end of the inquiry, there's an opportunity for closing submissions. So this is summing up your case based on the evidence that's been heard at the inquiry and the outcome of the discussion. It's not an opportunity to present any new evidence. The closing submissions will be in writing, and I'll allow a few days for these to be prepared after the close of the inquiry. The normal process is that objectors make their closing submissions first, and then the appellant makes theirs a few days later. But we'll agree the actual deadlines for those at the inquiry itself. So we're nearly there. Almost, it's 1 o'clock now. But if we just move on to the miscellaneous items, the daily programme. As has been discussed, we might need a slightly shorter day if we're going to be a virtual inquiry. I think it's acceptable to try and limit ourselves to around 5 hours. It is to be a virtual inquiry. We won't be starting before 10 o'clock in normal circumstances. And we'd always have at least an hour's break for lunch around the middle of the day. In terms of site inspections, I've made an initial site inspection to the Galloway side of the application site, but I didn't go into the South Ayrshire side because of the level 4 restrictions that were in place at the time. I will carry out a more comprehensive unaccompanied site inspection ahead of the inquiry, and that will include visiting the Merrick wildland area. But I do also anticipate having an accompanied site inspection at the end of the inquiry, which would include visiting individual affected properties if possible and if parties wish me to do so. And we can discuss the itinerary for the accompanied site inspection at the inquiry itself. DPA contact, Jane Robertson is the case officer for this case. Her contact details are included in the note, and they've also been included in the correspondence that you've received from her. So all communication with the DPA should be through Jane. And as I say, I'll do a note of the meeting. I'll aim to get that out before Christmas if other work permits. So if I can move on from that, anybody queries on any of that? Then if we move on to item 9, any other relevant matters, Mr. Campbell, I just noted there, I suppose I'm conscious about other processes where local development plan adoption or progress in the course of a or inquiry has given rise to a need for new evidence and so on. Do you think that any progress with the South Ayrshire LDP will impinge on our timetable at all?
I don't know, but of course we'll bring you the most up-to-date hot news about the development plan as it develops, and you can take it that if we need an update in the planning session, then my planning officer will provide that to you, so that you don't have to come back and ask for a fresh round of contributions once the evidence is all over.
Yes, I suppose I'm just flagging it now as a possibility.
That's very valuable. Thank you.
We've already had a discussion about the new information provided on private water supplies, but more generally in terms of environmental information, Mr. Innes, I don't know if anything you could say about how the extent to which circumstances have changed and the need for formal publicity for further information, thinking particularly about things like a change in the baseline cumulative impact.
The cumulative impact is dynamic and always will be. The fact that other applications have come in does not necessarily require further information with respect to this application. But what it might be appropriate for us to do is that to have today as a cutoff, we will do a check to see if there's anything that we believe should be brought to your attention in terms of the cumulative situation. And perhaps if we were come back to you on the same day as we come back to you on the aviation lighting issue with our review of that context to see if there's anything that we consider has changed that may require any further information to be produced.
And that would just, are you just talking about the cumulative situation there, or generally?
Yes.
All there's nothing else.
No, there's nothing else that I'm currently aware of that would result in the submission of any further environmental information.
Yeah. We would welcome that as well, sir, and we will keep an eye on applications as they come and go. I think there is a proposal, for example, to fell some forestry, which is relevant to this application. I don't know if that is necessarily fresh environmental information, but it may have a bearing on other aspects of the case. So that's the sort of thing that we can, I hope, cooperate with Mr. Innes's team on, so that you have an up-to-date picture.
Yes, that's a good point. It'd be very helpful if the council and the applicant could liaise on that note. Okay, that's all I had. Does anybody else have any other matters to raise? Mr. Shaw.
Yes, I'm not sure whether it's appropriate or not, but I'll try you with it, and you can slap me down if I'm wrong. It's really to do with the change of circumstances. We've got since the environmental impact assessment was created, we've got the Clauchrie wind farm extension with 13 turbines. We've got scoping on Carrick Forest, which is 17 turbines, and that's to the northeast of Clauchrie. We've got Craig and Moddy wind farm at scoping with 16 turbines up to 230 metres to the north of Clauchrie, which will join Carrick Forest up to Hadyard Hill. We've got Knockhodar wind farm, which is at scoping with 32 turbines, which effectively adds to the connection between Clauchrie and Mark Hill. So we're actually no longer looking at 18 turbines of Clauchrie in an area where there are no significant built structures already. We're actually looking at 78 industrial-sized turbines in an area which is almost entirely comprised of rural countryside and wilderness. So my contention was that actually there really does need to be a cumulative, significant cumulative assessment of the impact of all of these proposed developments, along with the fact that there are something like 347 turbines already in the triangle between Glenluce, Newton Stewart and Bar Hill. And between Bar Hill and Girvan, there's another 115 with a further 65 proposed. So I do personally think that there's a case for a substantial cumulative impact assessment, rather than the one which was produced as part of the development application, which basically said, this won't cause any trouble, will it? That's all I wanted to say.
Yeah, I think hopefully this note that the applicant will produce along with the council will highlight this, and we'll be able to see from that just how much the situation has changed since the EIA reports, and perhaps that's the time to take a a final view on what additional analysis or publicity might be required. But Mr. Innes, do you have any comeback on what Mr. Shaw has said?
Well, I think the difficulty with schemes at scoping is you just never know what's going to come forward. They're concepts at that stage and are not concrete proposals. They're given very limited weight in any consideration. Other applications are different, but I think it's an important distinction between other applications coming in and them having a consequence for cumulative assessment. And I think that's quite an important point, because there will be other applications that come in, but the issue is not whether there's been an application, but whether it brings to bear on significance of effects and whether that needs to be updated or not. And just being seen as not necessarily a significant effect. So it's that distinction of what is the issue in terms of the EIA regs for assessment purposes, and then secondly, in terms of decision making, it's a separate issue, and this is directed at the requirement for environmental impact assessment. That's the potential for significant cumulative effects, not essentially an analysis of what might have happened or might be happening in the general area. And I just want to make that point. This is very specific to EIA regulations, and there is a very limited assessment that can be done on scoping applications. And equally, we have to draw a line under this application as to how it's determined. It is essentially for those subsequent applications to assess us in the baseline in terms of their assessments, insofar as they're relevant, or otherwise this becomes a never-ending of circular decision making in terms of never being able to take a decision because another applications come in somewhere. So there is a severe limitation of what you can do with scoping applications, and insofar as what we will be looking at for January is the extent to which there's anything that's come into the equation which could give rise to significant impacts associated with this development.
Okay, thank you. Yes, I think we'll wait and see what comes in January.
Yeah.
With you on that. Ms. Spence, you had a question.
Yes. Careful to point out that you can't the things that are coming in, but I noticed that there are 3 applications which are current, 2 of which are in inquiry, were submitted. The Clauchrie once ahead of the Clauchrie one, which was 2 days ahead or behind, I forget which, of the extension to Kilgalliack. So I think it's rather cynical of him to make remarks about other people's applications, bearing in mind that when the Ultacannock application was put in, SPR objected to that on the grounds that they might have to switch off their turbines more frequently. So it's really does seem that there is a conspiracy almost between the various companies to keep shoving them in. And as Daniel Ferrier, who was managing the building of Kilgalliack, told me that the Kilgalliack extension is only asking for another 11 turbines because they can't fit any more in. And I believe that that is the case, that every single possible space where a turbine could possibly be put is now being applied for, and they're staggering it to avoid this investigation into the cumulative effect of the whole thing.
Okay, thank you. I mean, there's no suggestion that in terms of people's evidence to this inquiry, you can't make these points. So I don't want us to stray into the giving of evidence today. But your points are noted, and that you can certainly repeat them and make those points at the inquiry. Does anybody else have anything to any other points to make at this stage?
No, thank you, sir. I'd just like to thank you for the meeting. This has been long and arduous, but very useful, I think. And we all have a good picture now of what's ahead of us.
It's been a long one. Apologies for the technical difficulties, part of which was certainly at my end at the beginning of the meeting. At least you've had the benefit of not having to look at my face, which is something to be thankful for. So if there's nothing else, I shall thank you all for coming and for listening to what has been said. Wish you all a very Merry Christmas, and I'm sure we'll be in contact again shortly. And in the meantime, I think we'll stop there. Thank you very much.
Thank you.
Goodbye.
Bye.
Thank you.